Yes, Mr.
Well, item 50-51, these are substitution matter wrongly shown in hearing this, your lordship will take up without the
Order.
May it please your lordship.
Your lordship indulgence, I'd like to mention two items. It can come up for order.
Okay. When?
Any days convenient to you.
Next week? Next week?
After the election.
We'll have it on 10. Election is 7.
7.
8 is Friday, Wednesday. We'll have it on 10.
May it please your lordship. Your lordship, I beg to mention for listing two analogous matter, your lordship. Injunction has been granted and the matter has not been listed since November, your lordship. For admission,
IO, FAO, which one?
CRP, your lordship.
IO.
No, your lordship, it is arising out of ejectment to your
Ejectment for what?
tenancy, your lordship.
For hearing?
No, your lordship, admission.
We'll have it on 8.
Obliged.
May I please your lordship of CRP IO by 3. By the 3.
Why? New one?
No, no.
Old one?
We have also the second notice.
Hello? Friday? Friday?
No, no, no. We have taken a step.
You want it on Friday?
May I please your lordship? Lordship, I beg to mention item number 14 of the daily list. Lordship, Mr. R. Sharma, who was supposed to appear in this matter, is unable to attend this court due to his father's annual Shraddha ceremony. Lordship, may I adjourn the matter for today?
I for what?
Lordship, it is for combination of delay.
How much?
Lordship, that I am not aware of.
Hand it out and we'll take it. If it is more than that, if I think of dismissing it, then obviously no problem. I will adjourn it. But if I am not dismissing it, then I will allow. Everything has to move. Yes.
Lordship, prayer for lifting of an MC case arising out of
Which case?
MC.
What is that?
Miscellaneous case for restoration of Met Appeal 62, which was dismissed for non-prosecution.
Okay, 10.
Lordship, I beg to mention item number 14. In this item, we have filed a affidavit
14.
40.
What is that?
In this matter, we have filed an affidavit in opposition. So, Lordship may kindly allow it to bring on record. In item number 22, I paid for it. My senior classes father 1 year. Date and effect.
20?
22.
What is it for? Condonation.
For delay.
How much delay?
3,350.
How much?
3,350.
I 22. Who's senior counsel?
Yes, sir.
Okay. The learned counsel appearing on behalf of the appellant submits that on account of the death anniversary of the father of the leading counsel, the matter requires to be adjourned today. So taking into account the above, is the matter on 25, 2020.
My lordship, I beg to mention item number 17, my lordship. In this case, we have to take fresh steps in terms of respondent number 2 as per the last order. Only 1 week time may be granted.
No. If you have not taken steps, that is why the matter has come. No adjournments to this matter. Yes, transfer from where to where?
From Assembly Court, Campus Metro to District Dibrugarh.
Why?
The petitioner is suffering from cancer. Petitioner is suffering from cancer. And she is under treatment. Apart from that,
Where does the petitioner reside?
the petitioner resided in the district of Campus Metro.
Petitioner.
No, petitioner at Dibrugarh.
How do we know? See the cause title. Name of the petitioner.
Actually, this is the FC case.
What is this?
This is the FC case. Petitioner. In the case number
I am not bothered to that. You have shown him as the petitioner.
that is
There is no address, no town, nothing.
My lord,
City College, PO, PS, District, Assam. What is this?
my lord, page number 2,
Is this court required to find out on the basis of that? How can you maintain this petition in this manner?
my lord, page number 2, my lord.
I'm not going to look into all those things. Your cause title is wrong.
My lord, this is a FC civil case number, it is in the top.
The learned counsel appearing on behalf of the appellant petitioner submits that he would file a fresh memo of parties before the registry of this court, inasmuch as there is a mistake in the name as well as the address of the petitioner, who lists the matter
My lord,
on
in the-
6th. In the meantime, the fresh memo of parties be filed.
my lord, the page number 2, it is. there.
No, I'm not going to look into this page number 2 business. Where is the page number 2 out there? That is the thing which is being mentioned. Page number 2, where is the place? Show me page number 2.
My lord, that is.
Let us read it. Yes,
I'm
read it aloud.
I'm sorry.
No, read it aloud. Please.
I got it.
No, Mr. Gupta, kindly read it aloud for other people also to know.
The district and district.
No, wife of, read it.
Daughter of Sri Pulin Gogoi, wife of Dr. Sanjit Santanu Bhajati,
Hmm.
resident of Nirmatika, opposite of City College, POPS, and district, Assam.
Assam. Yeah. Yeah, what is the mistake?
Correct.
File a fresh memo.
It's metal receipt. On the same day of filing the application for amendment, Lordship, same day summarily the order has been passed by the trial court.
Why?
We were not allowed to file our objection or anything.
It was allowed on the first day
Because
without you had a respondent,
I am-
defendant.
I am for the petitioner, Your Lordship, in the matter.
You had a plaintiff.
Plaintiff,
They wanted to amend the counterclaim,
Lordship.
and the counterclaim was allowed.
Counterclaim allowed on the same day when they have filed the petition on 16 November 2023. On the same day, it was allowed without hearing us. We verbally submitted also to file our objection and other. It was not hard. Lord. We are in occupation of that land since the days of my grandfather, Lordship, 1940, Lord.
What is
No.
the suit? What was the stage of the suit?
Suit, Lordship, for framing the issues. Lord.
Okay, trial has not started.
No.
Now, you have filed a suit for recovery of possession.
No, we are in possession.
What was your suit for? Declaration of right
They
title.
they are disturbing us since a few years, Lordship. Since
Your suit was DAG number 39.
Lordship.
And what was their suit for?
The same, Lordship.
Then
but
what is the what was the
actually-
amendment made?
Amendment, they want to amend that this is a
That PP
Patna
number
land,
39
that is a Patna
and
land,
should have been PP number
Lordship.
2/30 here.
Lord.
So what is wrong?
Lordship, actually, this land was government land. Lordship. While we were occupying that land, during that period, without serving us any notices and anything, that has been made Patna in their papers.
Understood, Mr.
Lord.
The thing is, what is your, let's see your plain. Your suit is in respect of what DAG number?
Lordship, it was
DAG number, lot number, so and so.
Lordship.
Okay. Now they file their written statement come counterclaim.
Lordship.
In the written statement come counterclaim, what do they mention? Kindly see paragraph number 8
8 of their plain, Lordship,
of their written statement come counterclaim, page 34.
is 34, Lordship. Yes. Yes, Lord. That
There is a mention about DAG number 39
Lordship.
of PP number 847-366.
Lord.
Okay.
Lordship.
Then annexure 1 is the new Jamabandi bearing PP number 1 of DAG number 39. Land
Lordship.
measuring so and so.
Lord.
Okay. Then what are they asking for? Counterclaim 39 of so and so, PP number 39. Now, what else is the mistake? You have filed your written statement against the counterclaim.
Lordship.
You have filed the written statement against the counterclaim.
Lordship, we have filed. We have filed.
But if this amendment is being allowed,
Lordship.
how are you prejudiced?
Lordship, actually, this land was originally government land. We were occupying since 1940, Lord. And during our occupation, that land was converted to patta land.
Understood.
That is that.
Whatever may be, you have challenged that
Lord.
in your suit.
Lord.
Now they claim right title interest.
Lordship.
On the basis of that, patta has been issued.
Lord.
Now the patta which have been issued is in respect of patta dag number 335
Lord.
or patta number 2.
Lord.
They have inadvertently mentioned as dag number 39 or patta number 1.
Lordship.
They want to correct it.
They want to correct.
Then what is this wrong? It is your suit. The matter needs to be quickly disposed of. What objection you could have had?
Also, Lordship wants for quickly disposal of the matter because
Mr. Counsel, let me tell you one thing.
Lordship.
This amendment,
Lord.
otherwise normally amendments are not allowed in trial
Lord.
when the trial begins.
Lord.
This amendment, there is a judgment of the Supreme Court which allows where there is a wrong mention of the description of the land is being allowed even at the stage of arguments. If that be so, because it is the duty of the court under Order 7 Rule 3, read with Order 20 Rule 12, as well as under 152 and Section 47, to come up with a way that the land has been properly demarcated, described. Is it the duty? If you see Pratibha Singh's judgment. So if the court have done it, yes, normally the court needs to do it to give you an opportunity.
Lordship.
But at the end of the day, what will happen is your suit is stayed. Also,
That is there.
so it makes no sense. Yes, because I would have understood at the end of the time, trial also, if it is done also, that is be permitted. There's no
But-
quarrel with that.
It's a gross violation of natural justice. Lordship. We are not allowed any opportunity to file our objection or to hear us. That was not done.
We may or pass the order out there deprecating the practice. But the thing is, at the end of the day, the question of setting aside that order would be again re-agitating this matter again by allowing you to file, and then the court will decide the same. Because this is permissible.
So, Lordship, we may be allowed to file our objection. That liberty may be given, Lordship.
Now, if you file, the court is going to pass the same order.
Anyway, Lordship,
Then why do you need it?
because this land originally was government land. That part
That
we
is
are
your
doing.
case,
that
your
is our
claim, which remains as it is.
Lord,
There's no
that-
quarrel with that.
That is that.
But they have mentioned it wrongly. The dark number should have been 335. It should have been mentioned at 39. So they wanted to correct. So the suit has not progressed. Issues have not been framed. So under such what is the mistake? Yes, the court was wrong in giving you an opportunity and doing it. There's no quarrel with that.
That's why we have.
Yes. So, but that practice which is being followed, this court is I am agreeable for passing an order to that effect, deprecating the practice of not giving an opportunity. But at the end of the day, it will be the same.
Same, Lord. That
Then how does it make a difference?
yes, bro. It is there.
Because here you see 227 IO, this court is going to do only at the stage that so that the progress of the suit remains unhindered. There are some technicalities, some mistakes which have committed. This can be just corrected out there, nothing more than that. Because the basic idea is that the suit should remain unhindered.
Lordship, that is there.
Let the trial court decide whatever it is.
Okay.
Therefore, this is an application under heard Mr. So-and-so, the learned counsel appearing on behalf of the petition.
Yes, Das Gupta.
This is an application under Article 227 of the Constitution challenging the order dated 16/11/2023, whereby the learned trial court, that is the court of the Civil Judge Junior Division, JMFC Soraido, had allowed the amendment to the counterclaim had allowed the application under Order 6, Rule 17 of the Code of Civil Procedure 1908, for short the code, seeking amendment of the counterclaim without giving any due opportunity to the petitioner, who were the plaintiffs in the said suit. This court had daily taken note of that the suit which was filed by the plaintiff was a suit for declaration, confirmation of possession, as well as also for permanent injunction. Against the said suit, the defendants filed a written statement cum counterclaim. In the said written statement cum counterclaim, the details of the land have been mentioned as Old Jamabandi bearing PP number 847/366, Dag number 39, of Idiobari Bosisho Gaon, as well as the new Jamabandi bearing PP number 1, Dag number 39, of the same village. However, later on, the defendants cum counterclaimant realized that there was a typographical error in mentioning the Dag number and the Patta number, inasmuch as the Patta number should have been 2 of Dag number 355. And in order to correct the said mistake, the application was filed under Order 6, Rule 17 of the Court. This court also finds it very pertinent to take note of that in addition to that, now there are other amendments also being made. There are various other amendments
Yes, bro.
which have been sought for. However, on the very day on which the application was filed, the learned trial court allowed the said application. We issue notice and state. It is against the said order the instant petition has been, and the instant proceedings have been initiated. Issue notice, making it returnable. By you serve it, we finish it on 25/2024. Miss So-and-so, you are appearing. Mr. S. Dutta, appears on behalf of the respondent number 2 and Ms. So appears on behalf of the respondent number 3 and 4 and accepts notice. As regards the respondent number 1, the petitioner is directed to take steps by way of registered post during the course of the day. The petitioner further is directed to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. This court, in the above facts, and taking into account that there was no opportunity so granted to the petitioner to submit a written objection, states the further proceedings of title suit number 23/2022 pending before the court of the Civil Judge Junior Division till the next date.
Right.
Correct. Because he is asking for other amendments. These amendments should have been considered.
May please, Your Lordship, this revision petition arises out of the impugned order that has been passed with the execution proceeding for attachment and sale of the suit premises. In the year 2013, the petitioner executed an agreement for sale in favor of the respondent for the sale of the suit premises. Advance amount was paid and the delivery of possession was performed. So the respondent came into possession of the suit premises. In 2015, the respondent stated that he was not in a position to purchase the property, so he will return the advance amount. He asked for the advance amount and he would hand over the possession. So to that effect, and he also said that I need some time to relocate my family because I have no other residential house in the town. So an agreement was entered into in between the petitioner and the respondent in the year 2015, wherein it was stated that the earlier agreement for sale is mutually cancelled, that within 6 months the advance amount shall be returned and the possession shall be handed over by the respondent. After
that was made a decree.
After lapse of thereafter the suit was filed. When the petitioner, he went and offered the amount, the advance amount, the respondent did not receive the amount and he neither vacated the premises. So the petitioner instituted a title. In the title suit for specific performance of the deed of agreement for declaration of his right title interest and other ancillary relief. Now, in that suit, the respondent contested by filing written statement as well as counterclaim. In the counterclaim, he paid for specific performance of the agreement for sale of the year 2013, and in an alternative, that the advance amount had been paid to him. So that suit was decreed, and the counterclaim was decreed to the extent that the amount is to be returned, and the petitioner shall be entitled to the possession of the suit premise. Now, till today, the respondent is in possession. Now, an execution case was filed by the respondent, wherein the petitioner has been arraigned as the judgment debtor. And with regard to the judgment, the 7% interest was also levied on the total amount. As against that 7% interest, a regular first appeal has been filed before this honorable court with a limited period that the interest should be waived off. Now, Lordship, in this execution proceeding,
is there a stay in the regular first appeal?
Regular first appeal, there is no stay. There is no stay, and the counsels have agreed that they will not pursue for the 7% interest. They will only pursue for the advance amount. Now, they have filed a petition under Order 21, Rule 30 and 64 for attachment of the suit premise. Now, Lordship, the basic contention of the petitioner is that the petitioner is entitled to recovery of possession. Now, at the present time, due to some medical conditions and financial irregularities, he has not been able to pay that amount. But if the property is attached, then the petitioner, in spite of having been able to pay that amount, he will never get the possession back of the property. That is that contention was raised before the executing court.
I didn't understand.
That if the property is attached and sold.
Sale has not happened.
Sale has not happened.
For sale, they will issue notice.
They
that
will
is
issue
another procedure.
But the petition was allowed. And he was
only for attachment.
Or directed to take steps for the attachment of the property. So if the property is attached and sold, so even if the petitioner later on refunds the advance amount, he will not be able to get his possession of the suit premises. That is the basic content.
You are in possession.
No, I am not in possession. The respondent is in possession.
You are not in possession.
I am not in possession. I have handed
And
over
what is to be attached?
the entire artistic 3+3 building.
That was the suit property.
That is the suit premises.
And then if it is attached, it belongs to whom?
It belongs to the petitioner.
And you are not in possession.
I am not in possession.
How can it be attached? Well, how are you agreed with the attachment then?
The attachment that if it is attached and sold, then I will not be able to
Sale has not happened.
not happen.
Sale, no steps have been taken till now. But the question is, this is as regards the payment of that amount,
Payment of the advance.
where you have filed an appeal and there is no stay.
There is no
It is for recovery of that amount this order has been
this
passed.
order.
Now this property belongs to you.
Belongs.
So if it is now been sold, attached, how are you agreed?
Because I am also entitled to recovery of possession as per the judgment of the suit premises.
Who is in possession?
The respondent is in possession.
Show me your decree. Show me that decree.
Decree page number 45.
What was the earlier petition? As the executioner is pending for execution of the decree of money and refund of the money, it is court that it is not inclined to stay the entire execution proceeding. At this stage, the SP Florida and County respondent submit that they would not pursue the export of 7%.
The operating part of the judgment is at page number 59.
So, you are to pay 68 lakhs.
68.
That is admitted.
That is
And you have
admitted.
not challenged that.
That is admitted.
They will sell it. And he may purchase it. Very well. So, let them sell it for 68 lakhs. Court. And then if the other side let it purchase. Then you pay again another 7% on that. After your appeal is dismissed. The property is just attached, whereby the property has not yet been sold. So, how are you affected? You are not in possession of the property. As of you can very well raise that I am entitled my decree. Have you filed an execution application? Then give me a fair idea what to do. The order doesn't seem to be wrong. You have to pay.
Some time period may be given before
Why?
months. I will be able to.
Why should I give you? Executing court will give you. If you have any problem, the executive court will consider. Giving all these medical documents out here would not. This court doesn't have those things as regards fasting is 112. Fantastic. You have, what is your problem? What is your ailment?
Ailment, the highly diabetic cardiac problem.
Highly diabetic with fasting of 112. Grade 1 fatty liver. Everything is normal. Cholesterol is 167. Triglyceride is 132. What else do you require? Got a fantastic medical report. This of a person whose age is 64. Fantastic. This should be given out there in the TV, that a person should have such a good medical reports. Fasting blood sugar 104. Postprandial 135. What is the normal range? 145. And you are below that. Cholesterol max, it should be below 200. You are having 105. You are just losing out on the hemoglobin at 9.4, which should be 10. Better have some. You are a veg or a non-veg? Non-veg. Have some chicken to do. No case. Right? You have to pay that. File an application before you, because you did not contest. You have not asked for stay. Only the stay is only given for the 7%. Now, to this thing, why should this court stop it? You could have raised this very issue out there in the first appeal. You did not. This court is sitting only in 227 against an order of the executing court. The executing court is justified in passing this order. So, dismiss. Dismiss or withdraw? Withdraw. What has happened on the next date? The decree holder defendant is directed to take steps of attachment as per law and vacate possession on attachment. Who is in possession? The decree holder.
The decree holder.
He has been asked to,
On the
why are you before this court?
On the next date, has been informed that I have been informed today that they went the process server and Zarikara quit and they found the decree holder in possession, so they came back and gave it.
Obviously, they have caused a problem for themselves. They got an order for against them that they will vacate when they are in possession. The learned counsel, Mr. AIM, the learned counsel appearing on behalf of the petitioner submits that he would not like to press the instant petition, which have been filed under Article 227 of the Constitution, challenging the order dated 29/2/2024, passed in title execution case number 02/2022 by the Court of the Civil Judge, Senior Division, Borpeta. Taking into account above, the instant petition stands closed.
Deeply applied.
Yes, did you get it?
Yes, ma'am.
You are the defendant?
Even number one.
So on 11/3/2022, you made a prayer that you should be supplied copies of the certain documents.
Yes.
and the court proceeded ex parte against the other. And where is the order? That the plaintiff side has submitted the documents today. See, 11/3/2022. The order has been passed and the court have duly recorded it. That is why I wanted this order sheet.
It was real.
Yes. Then you did not. It is your responsibility. You did not. You did not take it on 25/4 and then on 8/7 you it was passed ex parte. What is wrong?
In my presence, my lord.
Huh?
Orally it was directed, my lord. Subsequently the order was passed.
Are you alleging against the judge?
That is the procedure followed, my lord.
There is not the procedure followed. The court mentions the plaintiff has submitted the documents today itself.
I understand.
Are you saying that this order subsequently the court
No,
modified
in
against you?
During the course of the day, it was
Obviously, why didn't you take? Did you check it out? That you have
there was a mistake on
There?
my part. That I
you received it on 8/7, that is your fault. Whoever to receive it after such a late long time. Then what happened? Kindly see 8/7. Defense number 1 is silent regarding filing of the WS today, whereas it revealed that defense number has received copy of the document from the case record today. But those documents were submitted by the plaintiff on the date of entering of the appearance of the defense number 1 on 11/3/2022. According to the statutory time of filing here is wrong. Rightly passed. Then defendant number 1 prayed for time for filing appropriate to vacate the ex parte order. Defendant is liberty to file. Then defendant number 1 filed petition on the order under section 21, read with so and so. Has filed written statement today. So the suit has proceeded hearing on 407. Then that application 4071 was rejected
rejected.
on 8/2/2024.
Yes.
Now what happened on 12/4/2024?
Well, for my lord, it was PO was on leave, man.
Where is the PO is on leave, fixed on 5/7. Okay. We are not saying anything. You noticed.
The caveator was there, man.
Huh?
Caveat was filed.
Where is the caveator?
Name appears.
Show me the name. Is there, it is good. नाम देखायचं नाही.
What analysis?
नाम देखायचं. Rubul Ali. Yes, Mr. R.K. Bhuya. Can you ask Mr. Rubul Ali to be present at after some time? Give him a call. We'll take it after some time. We'll allow this petition subject to cost of 50,000 on the lawyer. Your mistake. Your mistake. You were the lawyer. Fantastic. Him. 50,000 to cost. You made the
Hardship.
What?
Extreme
Extreme?
hardship to the client matter.
No, I'm not imposing upon the client. Him. He has to personally give. Not to the client. Client, I'm very considerate with the client. I don't impose. I impose upon the lawyer because it is his mistake the client has been put to. Of which 25,000 will go to the plaintiff and 25,000 he has to pay to his client for filing this petition. Yes,
I'm saying on behalf of RLA.
yes, where is he?
He's in chamber. He will come after lunch. I have no knowledge. regarding-
Fantastic. You are there. You have signed the wakalatnama.
I have no knowledge regarding.
His
this case.
name is shown
Yes, sir.
and he has not cared to appear. Look, we'll allow this petition. Go to the Supreme Court.
Kindly matter may pass over.
What is this chamber business? What is wrong with him? During the court hours when the matter is there, he is in chamber?
Right.
Is this the status of the I've never heard making submission to that effect that he's lying in the chamber. We'll allow this petition.
And lot of matter will be taken after
Sorry.
launch load.
Your submission that he is in we allow this petition and pay cost 25,000 to your client and 25,000 to them.
What was on leave actually at that time?
What?
What was on leave on that day, man?
On 11/3 was on leave.
Leave.
Mr. Potoki, do you want to share his burden?
No, my lord.
Then don't make that submission. I'll
Right.
then impose 50% on you and 50%
make it
on
late,
me.
my lord. Otherwise, it'll
No, nothing to it. This is an application under Article 2 to 7 of the Constitution, challenging the orders dated (8 to 2024) passed by the Court of the Civil Judge, Senior Division number 2, Kamrup Metro at Guwahati, in title suit number 07/2022, whereby the petition number 407/2022, filed by the defendant number 2.
defend number 1.
Why have you mentioned as defendant number 2 here in the petition? Filed by the defendant number 1 in the suit was rejected, thereby rejecting the written statement which was filed by the defendant number 1 on One 12/2022. This court finds it relevant to take note of certain relevant facts which led to the passing of the instant order. The plaintiff the respondents herein, who as plaintiffs had instituted a suit seeking declaration that the plaintiff and the defendants are co-owners of the suit land, semicolon, preliminary decree for partition of the scheduled land in equal 1/3, 1/8 share amongst the plaintiff and the defendant for realization of equal 1/8 share of the house rent at rupees 3,75,000 per month with 18% interest from January 2019 till realization, semicolon, issuance of a precept to the concerned circle officer and other officials for determination of the separate 1/8 share of the plaintiff and the defendant out of the scheduled land, final decree for partition, semicolon, permanent injunction, etc. The suit was registered and numbered as title suit number 07/2022. Pursuant to the order passed by this court on 29/4/2024, the learned counsel appearing on behalf of the petitioner has produced the entire order sheet. Had produced the certified copy of the entire order sheet of title suit number 7/2022. The same is kept on record and marked with the letter X. From a perusal of the said order sheet, it reveals that the suit was filed on 5/1, the suit upon being filed, summons were issued on 5/1/2022, thereby fixing 11/3/2022 for SR/WS. On 11/3/2022, the defendant number 1, who is the petitioner herein, filed an application, entered appearance and filed an application that the defendant number 1 did not receive the copies of the documents. The learned trial court directed the plaintiff to provide the copies, and the copies were duly provided on that said date in the records of the case, which is evident from the order dated 11/3/2022. The learned court, by the said order dated 11/3/2022, fixed 22/4/2022 for SR/WS of the defendant numbers 1, 10, and 17. However, on the said date, that is 22/4/2022, being a civic poll, being a local holiday, on account of the civic poll, the matter stood adjourned and was taken up on 25/4/2022, thereby fixing 8/7/2022 for filing of the written statement by the defendant number 1, 10, and 17. The record further reveals that the counsel for the defendant number 1 received the documents on 8/7/2022, although the said documents were duly supplied on 11/3/2022, as was recorded in the order by the learned trial court. However, on the ground that on that day, that is on 8/7/2022, the documents were received, the defendant again, number 1, again sought for time. Or you did not file a petition also. On the same day, the defendant even did not file any petition seeking an adjournment. The learned trial court, taking into account that the documents were duly received on 11/3/2022, and on account of the provisions of Order 8, Rule 1, and as the period of 90 days have already expired, passed the order on 8/7/2022 to proceed with the suit ex parte against the defendant number 1. It is also relevant to take note of that as regards the defendant number 10 and 17 also, the court passed an order in view of the fact that the period of 90 days had elapsed. The court thereupon fixed the matter on 9/9/2022 for SR of the defendant number 3 to 5 and 29 to 31. On 9/9/2022, the counsel appearing on behalf of the defendant number 1 filed a petition praying that he may be permitted to file an application for vacating the ex parte order. And the learned trial court granted the liberty to file such application as per law, thereby fixing 1/12/2022 for SR/appearance. On 1/12/2022, two applications were filed by the defendant number one. In addition to that, the defendant number one also submitted the written statement. Of the two applications, petition number 4071/2022 was the application filed for vacating the ex parte, whereas petition number 4072/2022 was an application filed under section 21 questioning the jurisdiction of the court. The learned trial court thereupon fixed the matter on 22/2/2023 for hearing on those applications filed by the defendant number one. After more than 1 year, that is on 8/2/2024, the learned trial court rejected the petition filed by the petitioner, filed by the defendant number one, that is petition number 4071/2022. On the ground that as the defendants failed to failed to submit the written statement within the stipulated period as mandated under Order 8 Rule 1. And there was no petition seeking time for filing written statement on medical grounds. The order dated 8/7/2022, a proceeding ex parte against the defendant number one need not be interfered with. However, the defendant number one was allowed to participate in the suit proceedings by way of cross-examination of the plaintiff, witnesses, etc. The learned trial court further fixed 12/4/2024 for hearing on the petition number 4072/2022, that was the application challenging the jurisdiction of the court to entertain the instant dispute, to entertain the dispute. It is against this order dated 8/2/2024. The present petition, the present proceedings have been filed. I've heard Mr. P. Kotoki, the learned counsel, appearing on behalf of the petitioner, and Mr.
M. Borolot.
Huh?
M. Borolot.
N. Bora,
Borolot.
appearing on behalf of the respondent, who is all respondents who are also on caveat. According this. Yes, now give me a good reason why you should be permitted.
Because actually, because actually is a party which was not to be.
Huh?
Because all properties are from Gorbeta.
So?
With the property which they sought to inherit, it is not a inherited property, still required.
So? No, why this court should permit you to
Actually, genuinely, what there was a mistake on the
of whose?
So,
That is why, to impose the cost of 50,000 upon the council, I wanted just from your mouth that the mistake was of the council. Mr. P. Kotoki, the learned counsel appearing on behalf of the petitioner, submits that on 11/3/2022, the documents though were supplied But the counsel representing the petitioner before the learned trial court did not receive those copies. He further submitted that on 8/7/2022 also, there was no application filed by the defendant number, by the counsel for the defendant number 1 on the presumption that as the documents were only received on 8/7/2022, the question of filing of the written statement by the defendant number 1 did not arise. He further submitted that as the suit pertains to a partition suit amongst the family members, for the ends of justice, the defendant number 1 whose written statement has already been filed on 1/12/2022 be allowed to be accepted, subject to such observations, such terms and conditions as this court may deem fit. What is your submission? That he is in chamber.
He has actually no knowledge, Lordship.
Who?
Regarding to this matter, Lordship.
His name is clearly shown in bold letters. Then, on the other hand, Mr. So-and-so, there he comes. Yes, you come. Yes, what is your submission? I am allowing his petition, subject to cost.
If your lordship peruse kindly all order sheets as well as
I have read the
petition.
I have read the order. Now, what is your object?
By order dated lordship that impugn order, it is very much apparent that they received copy of land as well as document much prior to filing their application. That is beyond the period under order 8 rule 1.
Then
So there is no any irregularity in impugn order.
there is no issue. I also appeal.
Then actually,
Then-
lordship,
So I'll impose them 50,000 cost, of which 25,000 they will pay to their client and 25,000 to you.
set up.
If your client waives the 25,000, it is a different thing. But 25,000 they have. On the other hand, Mr. R. Ali, the learned counsel appearing R. Ali On the other hand, Mr. R. Ali, the learned counsel appearing on behalf of the respondent number 1 and 2 submit that there is no infirmity in the order passed by the learned trial court on 11/3/2022, as well as also in the order dated 8/2, what is that? Order dated 8/2/2024. Oh, no, not 11/3, no. On 8/7/2022 and 8/7, na? 8/7 and 8/2/2024. And as such, the question of interference by this court under Article 2 to 7 of the Constitution does not arise. He further submitted that interference with such a order would render the provision of Order 8, Rule 1 would render the mandate of Order 8, Rule 1 nugatory. That's all. I've heard the learned counsels appearing on behalf of the parties and have given due and anxious consideration to their respective submissions. From the records, as already mentioned in the previous segments of the instant order, it appears that on 11/3/2022, the defendant number 1 duly appeared and submitted an application that the documents were not received. On that very date, the documents were duly submitted by the plaintiffs, which is duly recorded in the order dated 11/3/2022. No doubt, the defendant number 1 was not present, but the defendant number 1 was duly represented by the counsel. However, the counsel for the defendant number one did not receive the documents and in the most negligent manner kept the matter pending, knowing fully well the mandate of Order 8 Rule 1. It is also seen that the counsel for the defendant number one further negligently did not file any application on 8/7/2022 seeking extension of the period on the grounds that inadvertently the documents were not received on 11/3/2022. It is under such circumstances the defendant number one was proceeded ex parte by the learned trial court, and rightly so. However, one cannot forget a very pertinent aspect of the matter, that it was absolutely on account of the fault of the counsel which have resulted, fault and the negligent manner of conducting the case which have resulted in the passing of the order dated 8/7/2022. This court have also taken note of that on 1/12/2022, the written statement was filed by the defendant number one. It is also, this court also cannot be unmindful of the fact that this dispute is a partition dispute amongst the family members. And taking into account that the partition proceedings are not to be considered adversarial, this court is of the opinion that the ends of justice would be met if the defendant number one's written statement is being brought on record, is permitted to be taken on record. Accordingly, this court directs the learned trial court to take on record the written statement filed by the defendant number one on 1/12/2022. This court also, it is the further opinion of this court that such negligent conduct on the part of the counsel cannot be encouraged, which had led not only to the difficulties being faced by the petitioners who is the defendant number one, but also have led to the delay of the suit for almost 2 years in view of the filing and the pendency of these applications. Accordingly, this court imposes a cost of rupees 25,000 upon Mr. P. Kotoke. Whom? Upon Mr. P. Kotoke. Upon the counsel. What is his name? Your name? Huh? Upon Mr. D. Chakraborty, the counsel appearing on behalf of the defendant number one. To be deposited before the trial court on the next date, that is on 5/7/2024. Upon such deposit being made, the trial court shall accept the written statement so filed by the counsel, filed by the defendant number one. With the above, the instant petition stands. Keep it. Yes. What is this contempt matter? What is the present status of the proceedings?
My lord, on 6/4/2024 on the last petition, my lord, the respondent is not present and I was present in that on that date, and the court is also on leave matter. Therefore, the court is also on leave matter, and therefore on that day matter was fixed on 31st of May.
Let us have it on 1st of June.
My lord,
List the matter again on 3rd of June 2024, taking into account that the trial court proceeding is fixed on 31/5/2020.
Elliot.
Yes, what is this?
Lordship, decision appeal, misappeal against the order of injunction passed by the learned trial court, Your Lordship.
Then you have not got anything. Have you got anything?
Lordship,
Then I.
IA is not there.
What
But
is this appeal
injunction was
for?
ordered against me. I am the defendant there. Before the trial court.
Then?
So that
Which court
injunction,
passed the order?
Lordship,
Which court passed the order?
Lordship, the civil judge introduction number 1. That the impugn order, Lordship,
What is the direction?
Lordship, direction is to not to alienate, not to transfer the property. Initial order is there. So that earlier order was made absolute by the impugn order.
Interim injunction dated passed by this court. It made absolute. What is the interim order? Where is that order?
Lordship, at page annex of 5,
Page.
page 86. That is the impugn order.
No, earlier order.
Earlier order. Yep. That's the status order, Lordship.
Huh?
That the order was passed. That's the only status order.
What is that order?
That order is not me, Your Lordship. That the notice was served upon me, directing both the parties to maintain status quo as on 6/7/2021 over the scheduled properties as mentioned in the petition till next date. That was the interim order.
Status quo as regards?
As regards, no. Direct both the parties to maintain status quo as on 6/7/2021 over the scheduled properties as mentioned in the petition till next date. And that order was made absolute, has been made absolute by the impugn order, Annex of 5.
She is claiming some right.
Lord, he is claiming her right of partition properties, Schedule A and B property. So for Schedule B property is concerned, Your Lordship, that is a gifted property by our grandfather in the name of the different number appealant before the court in the year 1961. And that fact was known to the plaintiff response.
Who is the plaintiff?
Plaintiff is my sister. Plaintiff is my sister.
Then why you are fighting?
Lordship.
Why you are fighting? Why are you fighting with your sister?
Sister, Your Lordship. Because
And what is the stage of the suit?
this is now evidence state.
Then what is there?
Lordship, one thing. That property which was gifted, I am not on Schedule A.
Whether that Schedule B property is a part of the suit.
Pardon.
Whether there is a challenge to the gift.
They have not challenged the gift. In paragraph number 7 of the plaint, Your Lordship,
Why
Yes.
is the other side not represented? Notice
No,
have
no.
not been issued.
no.
Hello? We'll admit it, nothing to you. There's no stay. So let it come up in 2034. Yeah.
But the interim prayer was not made. But in the application memo of appeal was interim application was prayer was made. Not separate high application has been not been filed.
Who are the filing counsel?
I am the filing counsel, Your Lordship.
Huh?
Lordship, my junior is there.
Is it done from your chamber?
It's not him. So that is sorry for that.
I'm not bad nowadays in making remarks on the council and recording it in the order. What do you say, Mr. Bora?
Definitely. I'll separate application lordship only coming.
A person who is a seasoned lawyer out there in the trial court does not know that there is a requirement of filing an order 41 rule 5
5 okay. Generally, that's in the
and making a prayer in the memo of appeal. I would have understood. A weak lawyer may not that. But a person who predominantly does matters in the civil court, and I don't see him in other benches except in bench 1, and he makes it. Isn't it, Mr. Law?
sorry for lordship because I have not gone through it.
How about Mr. Bhuya? He's a trial court civil lawyer, and he makes a prayer out there in the memo of appeal for an injunction, for a stay. If I issue notice, you have to issue notice twice.
Lordship, then separate application, definitely I will file it.
What is the stage of evidence?
Now he has to lay the evidence for PW. But what happened? They file an application before the trial court for production of the document, which was in my custody. I produced it already. But some of the documents which is not in our custody, we cannot produce it. Accordingly, court directed him to lay the evidence. We produce it. We produce.
So, it is
So,
in
but
the evidence.
I am not on that. That may proceed.
Suit of the which year?
Of the
21.
2021.
So, by the time notice and everything has happened, till now you have already, notice was issued on nothing. The matter first came up before this court on 28/7/2023. And
Yes.
till date, notice has not been issued. Hello, let us admit
We are in
that.
possession.
Okay, you are in possession.
We are in possession.
Then what is there? Are you going to sell up the property?
No.
Then what is the problem
I'm
with
not
the
going to
status
sell
quo?
off the property, but so far my submission before the lordship. So the good property, we have made a statement, and she herself made a statement in the plain that their grandfather made a gift some of the property in respect, made a gift in respect some of the property. That gift includes my gift also, and that is in respect of equal fee property. And it was made in the 1961. That gift has not been challenged in this suit. Till today, they have not challenged the gift.
So
Now-
that is your plea in the trial court.
Yes, that is trial.
Then what? If
That,
you are
that
not
I
going
have
to sell it,
constructed a G+5 building over that for particular plot of land. I
Then-
am in possessing that. Now the learned trial court, what is observation made?
to the order, the observation shall not the effect in the trial.
That observation, just single one line only.
Mm.
Per contra, the opposite party has submitted photocopy of the gift deed, and schedule of the gift deed not appears to be identical with this schedule land. Even if the court realizes the gift deed, then also it does not clarify that the entire property in dispute is gifted to Obi by his grandfather.
Where,
That-
where?
That
Per
at page
contra,
92, your Lordship.
contested the, which paragraph you are referring to?
Paragraph number 17, page 92 of the impugned judgment.
Per contra, OP has submitted the photocopy of the gift deed and the schedule did not appear to be identical with the schedule. Even if the court realized the gift deed, then also it does not satisfy the that gifted by the people. It claim based upon the fact that in India, during the so withdraw,
So-
withdraw, and I will make an observation that all these observations shall have no bearing in the trial.
So-
Unnecessary, because the status quo which is given is a very
Take one.
vague status quo. So you can do many things. You can take advantage of many things.
So this observation, you may have find it good.
The instant appeal has been prepared under Order 43, Rule 1R against read with Section 104 of the Code of Civil Procedure 1908 against the order dated 29/3/2023, passed in midday case number 368/2021, arising out of title suit number 257/2021. From a perusal of the said order, it reveals that the learned trial court directed the parties to maintain status quo as regards the suit property till the disposal of the suit. This court duly inquired with the learned counsel appearing on behalf of the appellant as to what is the stage of the suit. And Mr. R.K. Bhuyan, the learned counsel, submitted that the suit is at the stage of evidence. He further submitted that the status quo order he however submitted that the petitioner herein, the appellants herein, are primarily aggrieved by the observations which have been made in the said injunction order, inasmuch as if these observations are so made and taken into consideration by the trial court at the trial of the suit, it would prejudice the appellants. The learned counsel further submitted this court have duly taken note of that the injunction order and the impugned order, and is of the opinion that the said order do not fall within the mischief of being unreasonable, arbitrary, irrational, or in violation to the professed mandate for grant of an injunction. The well-settled mandate for grant of an injunction. Under such circumstances, this court is not inclined to interfere with the order dated 29/3/2023. Be that as it may, this court makes it very clear that the observations so made by the learned trial court in the said injunction order shall only be construed as observations for deciding the temporary injunction application, and the same shall not affect the decision of the trial court in the suit. Appeal accordingly stands. Next time, Mr. Bhuyan,
Lordship,
don't make this type of mistake.
Lordship, Lordship.
Challenging what?
It is against the injunction order, Lordship, not. I am not against the status quo order has been passed. Both the parties are direct to maintain status quo. I am not on that. But observation has been made in this case also. Both these cases. There are two miscases before the trial court. One miscase was filed by the appellant, and one miscase was filed by the respondent. And both the miscases were status quo order has been passed.
Then?
That observation has been made by the learned trial court holding that the defendants were in possession of the suit property. So both the matters to be heard together, fixing the date, Lordship.
Mr. R.K. Bhuyan, the learned counsel appearing on behalf of the appellant, submit
Lordship.
that along with the instant appeal, there is another appeal being FAO number
69/23.
69 of the 2023 are connected. Taking into account the above, matter on 8/5/2024, along with the state. Yes, what is this?
Lordship,
What are you challenging?
this petition directed against an order passed by the learned trial court in H2 arising of an application under order 39 1 and 2 by issuing the proposed notice almost virtually
The
refuting
notice
the
was
grounds
only
in-
issued.
Not-
Yes, what was the injunction sought for?
Injunction was Lordship, this Chhatribari Christian Hospital Lordship. They were having a road on from the eastern side of the hospital here. The hospital is having 76 acres of land. So there is a road, public road also from the eastern side, that is Bortola side of the hospital. Bill. So that, and they are using the land since 1969, that is for last 55 years without any interrupt. Lot. And it is the petitioner plaintiff lordship who had developed that road plot, which is a government land. So all of a sudden, lordship, the defendant started to close the road lordship by erecting the boundary wall lordship. That your lordship will see the lordship may come to page 56 to see the first of all, lordship may please to come to page 50 annexed case series lordship. This is the road lordship. The original status of the road lordship.
Where is the GMC council?
Mr.
Yes,
Bora. Yes. You are. Then lordship, the next page 51 is also showing the position of the road and the boundary wall of the hospital lot. Then the next page 52 lordship. Page 52 lordship, this is other two photographs lordship showing the existence of the road and the starting of the boundary wall by the defendant lordship over a part of the shootland. Then lordship may come to page 53. This is also the photograph showing the road. Then lordship may come to page 56 of annexure N. All of a sudden, lordship, the GMC started to construct a boundary wall closing the entrance gate of the hospital from the eastern side. Eastern side. This is the on the showing the hospital campus lordship and the construction of the boundary wall by the GMC lord.
What is this big piece of paper you have?
This is regarding the showing
the
the
land?
position of the land and the road lot.
Page 52, what is this land?
Page 52 lordship. Page 52 is lordship the photograph showing the road lot and the part of the construction is started by the GMC lot.
This road, page 52, this road they are trying to block.
Block lot. And they have the subsequent photograph will show just in front of my stern gate of the hospital, but they have closed the ingress and egress of the lordship. May please to come.
Now, where is your hospital in the photograph?
Hospital is lordship on the western side of the road.
Where? It is nowhere seen in the road.
Lordship,
We don't see the
lordship may come
hospital
to page
anywhere
58.
nearby.
Yes, lordship may please to come to page 50.
50?
58. This is the gate which has been erected by the GMC lordship closing my entrance, and on the back side of his lordship is seeing the boundary wall and the gate of the hospital.
No,
So
where is
now
the
after
hospital?
erection of this gate, lordship, the emergent, in case of emergency of the
Now, Mr. Roy, where is the hospital? Nearby.
hospital is beyond this boundary wall. Lord.
Where? You don't see the hospital anywhere, any form, from any other district. Where is the hospital?
Lord, hospital photograph.
Then
Main
how do
building
we
is-
say that it is on the eastern side of your boundary? We don't see any hospital anywhere.
Christian hospital, Chatibari is.
I know where the Christian hospital is, but where is the hospital in this photograph? In the near vicinity, where? That is why I asked you about that map. Yes, what is this?
Part of the
What is
building,
that?
is there. Part of the building is
Page
there.
number 46 is given a map.
57 is there.
46 is given a map, colored map.
Ah.
But they have already have an entrance. They are
Huh?
using a government. That particular land where
Hmm?
construction is going on is a government land.
Where?
Page number 46.
Where? White Memorial Hospital. Then, which
I
is
think
the,
this is the left hand side. There is a one thing written there, main gate.
now where's the Christian hospital?
So that's very difficult to detect, my lord. There is a charge. The main hospital in the left hand side, my lord. Main hospital is written.
Lord, you may come to page 53, which is clearly showing the hospital gate, Lord. And behind that, the
where
building
is
is
it?
partially visible.
No, there's nowhere the hospital is in. Which one?
Page
Is
53,
this-
Lord.
White Memorial Hostel.
Hostel is also there, nursing college is also
Where's the
there.
hospital in this photograph you have added as annexure H? Or main hospital this way?
Well,
Boundary
Lord,
wall.
this may be taken on Friday. I will annex the photograph, entire photograph.
Full of nerve. Where is the road you are making? Main gate is there.
The main hospital is there. OPT is there. Ward is there. There are 2 wards, 3 wards.
Page 56 also showing the hospital gate, Lord.
Where?
Page 56. Page 56 showing the
Where?
hospital gate, Lordship, and
Which
behind that, the entrance.
The trespassing prohibited. That is. That one. The hospital gate.
Hospital gate.
Notice
left-
trespasser
left
prohibited. This property is of the council. Yes. This one. Where is the hospital nearby? No hospital, nothing. It's all plantation.
No, gate, Lordship, the page 56, Lordship.
That is what?
It is
Where is the
clearly,
hospital? You have
deleted.
trees.
then this will be taken on Friday. I'll give the photograph.
Do you see any hospital? In
No,
page
in
56?
the photograph, it cannot be seen, my lord. All 3.
But there is a gate.
There is
It says that the property belongs to Council of Baptist something churches, North East
North-
India. But beyond that, you have the hospital or not? How do I know? And you should mark it properly.
Okay, Lordship, I'll supply the photo.
And another thing, this road just next to that gate. What is that road?
Page, Lord,
Page 56.
page 56.
You see, there is a gate being put here.
Yes.
This
There is a gate.
construction
This is the
gate is
gate
being
of the
put out here, but there is a road. You
Huh.
see a road which is going out there because this aspect is clear from this one. Nah? So these people used to come from here and get into this road. And why are you closing this road?
This is the boundary wall of this is a common land. There we GNC is constructing
No,
a
the
boundary wall.
next land. You
Next
see,
land is-
kindly come to page 53. You get your instructions. You see, the wall on the back side seems to be the wall of the plaintiff.
The construction where it is going is a government land where the GNC
No,
is
no,
going
no.
to construct.
This wall where there is some structure out there. You see at page 53, top.
Yes.
This seems to be the land of the plaintiff. Now, in between this and this wall, the wall without a gate, or nothing is there, or there is a road out there. Whose land is this?
That-
You just get in. And where is it located in page number 46? Mr. Roy, you get it.
I'll give the DRDO photograph.
Huh?
Human app as well as DRDO satellite photograph. It will disclose in detail the entire country by doing the drone search.
And when is the next date fixed?
Next date, Lordship,
Next date is fixed on 23/2024. We are in the month of May.
Yes.
Then what happened in the meantime?
they have closed my entrance gate.
Now what do you want? To break open?
I'm praying for a permanent injunction and mandatory injunction.
For breaking it?
Yes.
So now you are asking for what in this appeal?
I'm asking Lordship that at least they should be at present maintain the status quo.
What
If
status quo?
In respect of ongoing construction.
You have filed an IA.
I
IA for what?
Order 39 goes.
Yes, but IA for what? But they have already constructed.
Wrong date.
They have constructed, that's why there is a prayer for mandatory.
Where is it?
Demolish.
Where is it? Directing the opposite party and their men to clear obstruction upon the Schedule B land caused by the Iman by demolition of the brick wall. Now, did you make a prayer before the trial court?
Yes. Temporary.
Where is your injunction application for that?
Lordship. Page 60. 60.
Hmm?
60.
30.
60.
60.
Prayer portion is Lordship active. It starts from page 60.
So this is an interim mandatory injunction.
Yes.
You wanted an interim mandatory injunction at that point of time.
At that time before the learned trial.
Did you ask for that?
Yes.
And that was refused.
So the only so-called notice was issued. Without existing prima facie case.
That was refused.
No, not necessary to discuss everything.
Page 72 onward. That was refused because there is an alternative road. 72 onward.
And it was
Order
only
dated
notice
28.
was issued. What happened thereafter on 23/2024?
Notice was issued, Lordship. Thereafter, Lordship.
You are only challenging this order. 23/2024. In the meantime, when a notice is being issued, this court is only going to consider till the notice period what has happened. Now, what has happened to the injunction application?
It has not been, they have not even filed their WS.
WS is not required. They may file the written objection.
No, that has. They had not even appeared till in spite of the.
Is it?
Even in the lower court, I have no idea.
You have served. Where is the order thereafter? On 23/2024, what happened?
I
There
Release
is
the
only one
matter
order,
on
my lord, at 28-2.
release the matter on 6/5/2024. No, not on 6/5. 3/5/2024. On which date? The learned counsel appearing on behalf of the appellant shall apprise this court as to what further orders have been passed by the learned trial court on 28
20.
23/2024, and as to whether the respondent GMC have duly appeared in the said proceeding pursuant to service of notice. Mr. Here you also find out. In fact, this appeal is to be dismissed on that day.
Lordship, I have acquired right of easement.
Understood, but you see, this is against the notice. Notice period is already over on 23/2024. And thereupon, whatever happens or any order is being not passed or anything, you need where an order subsequently, these aspects have to be brought. You have to ask that immediately done. Now, any construction has been done now. You want a mandatory injunction for this court to pass when you are asking where the trial court is yet to decide the mandatory injunction application.
I'll file in it.
I'm
Item
giving
7.
you another 1 day only for the purpose of it looks better that on first date not to dismiss. Anyway, hello. Yes, RSA.
First, appellate court got application for contradiction of delay. There was 50 days delay.
How much?
50 days. The ground cited was for the ailment of attending the ailment of one family member. That much was only stated. That lordship will find that page 66, 67, 66, paragraph 4.
Where are your substantial questions of law?
Lord, page 76, man.
Page?
76, man.
Why is it not a former part of the record? Mr. Doctor, what happens when an appeal is dismissed on a limitation point?
It is considered as a decree, but that's the
There's no quarrel with that. It is a confirmation of the decree.
exact.
So your second appeal, questions of law, don't you think has to be on the trial court judgment?
Yes, well, I've got properly.
This is not the question.
Not
Then, because if we remember the judgment of 2001 Supreme Court, it says that then it has to be treated as if it is a second appeal against that.
well, I've tried to move with it. But what is happening
Again,
my lord?
how does number one have question of law?
My lord, number 2, my lord. Number 1 was already there, my lord.
Whether non-framing of an issue on oral family settlement between the parties was fatal in the instant suit, as the state aspect was not even discussed by the trial court while deciding the. Did you give evidence as regards the oral partition?
Yes,
Then if that be so, then what is the problem?
my lord, that was the learned court did not even enter into that. That was part of the evidence, though, my lord, but it was not never.
Why didn't you file an order for 14 Rule 5 application?
That was, of course, not right.
Then how do you raise this as a substantial question of law?
But that particular evidence, my
Whether trial court committed perversity in failing to appreciate that the oral partner between the parties was not compulsory registrable under order. Let us see how does the trial court decide that.
my lord, will find. I'll put it at page, my lord. It starts at page, my lord, 40. Sorry. Starts at page 26, my lord. And my lord,
Where is your statement as regards oral partition? It was an oral partition,
it was an oral.
so it has to be based on evidence.
Yes, sir.
Where is your statement in your pleadings that there was an oral partition?
Yes, my lord.
You are the defendants.
I'm the defendant. My lord. Lord will find my written statement. My written statement, my lord, is at page, my lord, 15, my lord. It starts, my lord, is this, my lord, I, my lord, narrate the fact, my lord, from page 19, my lord. The real paragraph 12. So the real factor is followed. That the plot of land measuring 20,
You are mentioning about G, page 20.
my lord, 20, yes.
This is the partition,
Yes, sir. That is what
oral partition, and according the revenue authority also mutated the name of the plaintiff number T, namely so and so, along with the plaintiff numbers so and so, and also the names of the defendants, namely Ranjit Kulcha, were also mutated over equal portion of land covered by dark number so and so. This is the partition.
Yes, sir.
Now, as per the settlement of the dispute, the area of land measuring so and so, the area was equally divided amongst the plaintiff and the defendants and took possession of so and so, so and so, so and so. Okay. Then, how does the trial court frame questions of law?
Trial court, my lord,
The
will find the issue. My lord,
what are
from
the
page-
issues? whether the plaintiff, whether the plaintiff has right title interest, whether the plaintiffs are sharers and legal heirs of the plaintiff number one, whether the mutation or the fraudulent, whether in the course of the trial is coming. The issue number 3.
Issue number 3 is 843.
Report that the defendant is But your person have duly admitted that the original owner was somebody else.
That time the annual patta letter. When the patta, our cases we are staying together. But the patta was of course in his name.
Whatever maybe that it was in
Then
his
the
name.
But when the registration was done, after we came to know about it, we got out there was settlement, and it was raised very now and then.
Not raised and muted.
Muted.
Then
In fact, the plaintiff's mother's name was also included in that mutation. That is the plaintiff number 3. So, her name was also mutated at that point of time in 1995.
finally come to page 46,
46.
issue number 4 and 5.
Right.
See there. The defendants have been mutated their name in the dark number 21 as sharer along with the plaintiff number 3 white order dated. This is the mutation order.
Yes, the
The defendants either exhibited the certified copy of dark number 56 as exhibit A and certified copy of star number as exhibit B, which discloses that the defendants have mutated the names as sharer along with the plaintiff. However, the defendants have admitted that they are not legal. What is heirs of
actually,
the legal heirs of Gandharva and the suit land belong to Aya, which was inherited by the plaintiff after the death of Gandharva. The defendants have mutated as sharers, but to be co-sharer, there has to be a transfer or suit land must be devolved upon the sharer by right of inheritance. In the instant case, the defendant did not adduce any evidence to establish that the suit land was purchased by them or they were the legal heirs of parents. Admission of the defendant also goes to establish that they are not the defendant. Now, if you have no ownership over the land, then isn't it, can it be done through an oral party? That has to be raised.
But it was about because the party our case is that our father and my uncle, they were residing over the land. It was inherited from their grandfather. When this land was made patta in 9 because premium was paid and it was converted into periodic patta. At that point of time,
Did you pay the premium?
That aspect evidence is
Those evidence are not there.
not there.
Unless you show that you have
Our case is
also,
not that very
or
large.
it was a paid out of the joint family.
That evidence is
If that is not your case
that is not-
anywhere,
that is
how do you bring it? You only say on the basis of GNA. Then look here, we were staying together. There was a oral partition and settlement. There were disputes
Oral-
on account
oral
of that. It was said that okay, I will have it, and accordingly mutation was done.
oral partition and consists of 90 rupees. That's what 90 rupees. Oral partition is the kind of transfer along basis of 90 rupees.
Whatever may be transferred, their oral partition also it's okay.
Fine.
But the question is, when the land out there
Fine. belong
to somebody, to be another person, a sharer of that land or to confer a right,
Fine.
wouldn't it now be hit by 17?
Our case was that's why the 90 rupees consideration came in the value of less than 100. That's what reduces the evidence of the site personal state by both the PW1 and PW2.
Value of the land.
Value of the land.
What was the value?
It was consideration was 90 rupees.
How can you make it 90 rupees?
That's what was stated. That is what has been stated. That is
Where is your in your pleadings that it was 90?
it was there. It's there. It's there. G, my lord.
Decided to give the equal portion of the land under EI in favor of the defendant, namely Ranjit Kolita and Moniram Kolita, on consideration of rupees 90. Then
That much only.
where is the payment of 90 rupees?
But that, of course, has not been denied, my lord. That has not been
Did you ask that question? Did you put it that 90 rupees was given?
That was in my in my cross.
No, in your evidence, did you put it? Because in your evidence, you categorically said that you are not the owner. The owner was Gandaru.
Consideration 90 rupees was stated in the evidence.
Huh?
Consideration 90 rupees.
Stated as what?
That is the same way, my lord. Consideration of 90 rupees.
What was that? How much is the land?
Land is, my lord, around, my lord, this total land, that is, my lord, that to be in dispute, is, my lord, around 5 bigha, my lord, 7 bigha, my lord.
Where?
But fine, so that the plaint itself, my lord, they have made a statement, my lord.
Borbeta.
Borpeta. In fact, my lord, there are 5 plots of land, my lord, and 5 dags, my lord. Out of that, 2 dags, my lord, were handed over to, my lord, the defendant. Paragraph 2, my lord, is the.
So schedule A land
Well.
is 2 bighas.
Yeah.
2 bighas covered by so and so, of which so and so, so and so, so and so. An area of land measuring 6 bighas covered by so and so. Oh, the land is totaling is 12 bighas.
Total is 12 bigha, my lord, but that.
And you got it transferred how much? 90 rupees.
90.
Can't be that the value of yeah cannot be said that we have made it to an year 90. Anyway, this is the first day matter has come.
Well.
I give normally another chance. Oh, many times it has come. So
Well,
nobody even have dared to.
It's come to block people first time, madam.
Okay. And it comes before me for the first time. I give one additional chance before dismissal. Chalo. You don't have that substantial question. Because on delay, it's a question of. Even if it is a mixed question of law and fact, also it is goes outside the purview of substance. Only there might be some cases of delay where the delay has occasion on account of non-consideration of the Supreme Court judgment during that period. In that cases only I have framed that question of law because yes, that would be a question of law that non-AIR would it amount to permissible. Because there was a judgment. Because
Right.
there are many cases you will find in second appeal where these people have the trial court have or the first appellate court had dismissed the a condonation application without taking into account that during this period there was no limitation. So there you can. I have framed some questions of law. But primarily in this case, in view of the 2001 judgment, the only thing is that we have to see as to whether that judgment any substantial question, or because it amounts to a conformity.
Right.
But from this, it doesn't appear. When there is a question of the finding of fact arrived there, that they are the owners. Because when any evidence, you look into the evidence, get a copy if you see, as to whether that evidence would have otherwise taken, would have otherwise changed the issue.
Well, I'll bring those evidence to record.
Don't bring, you have a look.
Right.
We'll have it on the next day. You just find out that.
Fine.
Huh. How much time do you require?
10 days time.
At the request of the learned counsel appearing after the appellate matter to be again listed on 10th of May. On which date the learned counsel shall produce yeah.
But it is not otherwise inconvenient. It
Hmm?
is not otherwise inconvenient to lordship can 50.
Okay.
Keep the lordship. I think October, I think the past after the Yeah.
First time. At the request, this is the first time, huh? Second time, no more. At the request of the learned counsel appearing on behalf of the appellant, matter stands adjourned to be listed on 15th of. Hmm.
The transfer petition, your lordship.
Hmm.
And the last date, we were directed to take justice certificate.
Upon
Upon response number,
what is this matter about matrimonial?
no, your lordship, it's an MSCT.
MSc
Oh,
claim
that
case,
one.
Yes, your
lordship.
lordship.
I granted a stay.
Yes, sir. Upon the regional manager, HDFC officer, who took the
Recently, there is some judgment which has come up on this aspect, where it is to be filed. In the earlier of the case, huh? You are appealing for whom?
Lordship, two transfer petitions have been filed, your lordship. One by the claimant and another,
These are insurance.
no, lordship. Claimant
we had a claimant in the original-
original claim application.
Okay.
And I am opposite party, lordship. So driver and owner, your lordship, in the original
Where
application.
did you file?
I
Oh,
have
you are filing. The insurance is not here.
insurance is not here, but
Who is the insurance? What insurance is it?
HDFC Argo, your HDFC Argo.
HDFC.
That
Who appears?
no one has appeared, your lordship.
Who appears for HDFC Argo? Mr. Argo Sami.
The second step by
No, taking steps, the matter to be delayed doesn't happen. We do one thing, we vacate that order, then automatically steps will happen.
lordship, steps has been taken, and your lordship, in item number 45, office note may kindly be seen, lordship. Second file, your lordship.
But with regard to the notice of an by UTS step, oh, service is complete here.
Yes, your lordship.
Now what do you want?
Lordship, the opposite party owner driver and the claimant put the petitioners filed
is
this
where?
petition to Sibsagar, your lordship. The
Where
accident
did the incident happen?
ex Sibsagar, within district of Sibsagar. Geleki.
In accident happened in Chipsagar.
Yes, yes.
Who filed the claim petition out here?
it was inadvertently filed there.
Huh?
it was inadvertently filed here. But the
By?
claimant actually gave the claim petition to the advocate there, but he filed it there, Your Lordship. Go ahead.
So he wanted to come here in Guwahati.
No, Your Lordship. The
Visit
claimant
the
doesn't
mall.
want to come in. It's way long from there, Your Lordship.
No, the lawyer may like.
Yes.
Now you want to displeasure your lawyer.
No, actually, we want to appear there, Your Lordship.
Now, both these applications are taken up together, taking into account that the application arises out of the said the application are applications seeking transfer of MSc case number 1347/2021 pending in the court of the learned member MSCT number 3 Kamrup Metro at Guwahati to where
MSc Sipkagar.
MSCT is MSCT there also
MSCT
there
MSCT district judge has been taking the MSCT matter.
MSCT is there or not Sipkagar?
The tribunal may not be there. Tribunal may not.
Find out. We'll take it up at 2. Find out both of you. Okay? So,
Lord,
find out.
district
Let me know
judge.
whether there is a MSCT in wait,
District judge.
because if I say it MSCT again, you come back out here without the MSCT. In many cases, it is not big. You see, district and session judge come, special judge come, member MSC,
District judge in the district.
president DCRTF, Siptagar.
Not.
We'll take after some time, huh? Just we speak about MSCT, Siptagar, and district. We'll dispose of both the matters.
Lordship. I'll also.
Yes, Mr. Bhatti.
My lord, I have challenged the validity of order 10/7/2020.
What are you
Marked
challenging? Validity of
My lord, the order, include order is 816 by. What is
815
16
16.
16?
There is a-
What has happened in this?
Now you want to produce by yourself.
Original.
You want
Because
to.
at the relevant time.
I understand. Now you want to do it by yourself.
Yeah.
That's it.
Yeah.
So what is the problem? Yes. What type of objections you are giving out there in the trial?
No, my
You are a lawyer.
kindly, this same prayer is pending since 2019, madam.
Understood, Mr. Siladitya. Everything understood. Earlier, he filed a petition saying that the Reserve Bank of India has it, or whoever person has it, because of some law. Now that those applications were rejected, and the matter came up before this court, where this court directed them to go withdraw and file an appropriate application. Those applications have been rejected. What do you mean? Now the question out here is that now, after the liquidation of the loan, the documents are with him now. So he wants to produce it. That's it. What is the wrong thing?
Kindly see, my lord. The last order, my lord, passed on 25/10/2021, my lord. Then they have filed after 2 years or 1.5 years, the present application.
What is the stage of the suit?
PW, my lord.
Oh, very well. They can bring it.
And we have a counterclaim, my lord, that effect. We have
Oh, what? You may have a counterclaim, so how does it matter? You will cross-examine those documents. It is not that he has not mentioned about those documents.
They have not mentioned about those documents in the pleadings, my lord. Somehow in the evidence, my lord, they have bring those documents.
No, they have not mentioned about these documents in the trial court.
No, my lord.
In the plain.
No, my lord.
What do they say?
Nothing,
what are
my
these
lord.
documents?
Nothing, my lord. These are the documents of their, my lord, mortgage deed, my lord.
So did they mention that there is a mortgage?
No, nothing was mentioned, my
No,
lord.
no, I'm asking you, Mr. Riyaz, was there a mention that there is a mortgage?
No, my lord. No.
Are you saying that there is no mortgage?
Kindly see, my lord, the impugn order, my lord.
No, impugn order I have looked into. 10/7/2023.
Yes.
Yes, I have looked into it.
And impugn order itself is reflected, my lord. The main base, my lord, they did not submit anything in the pleadings, my lord.
No. Impugn order says that if he ought to have stated in his pleading if the document was not in his possession.
Lordship.
But now it is in his possession. Earlier, rightfully, those things were rejected. But now he says that the documents have been liquidated, and now I have the document. Let me produce it. So, yes, where is the statement that these are mortgage deeds? Yes, Mr. Bhatti.
My lord, for that aspect is specified that those documents are.
No, I don't want that. What are these documents? Exhibit 1, 16, 17, 20, and 21.
Documents, my lord.
That is sale deed number 1967, but that is page 69, my lord. Page 69.
Sale deed number 1967, Jamabandi, Patta number, mutation order, no objection certificate by Guardianship, site plan approved by so and so. Now let us see. Yes, paragraph 1 of the plain, he mentioned about the deed of sale of 1967. Mentioned. See? Then, Jamabandi. He mentioned it at paragraph 6. Mutation order. reconstructed 2 Assam houses, their own out of 11, and 1 Assam type was given to his younger brother. And this construction was made in when? 2000?
Yes, my lord, and those documents I
Okay. Well, No.
So that aspect of matter, my lord, the earlier division which was allowed on withdrawal, my lord, that was asked to file a proper application, my lord. That application has been filed after 18 months, my lord, after the disposal of the revision petition, my lord.
Understood. But now, when did they get back the document?
during the pendency of the earlier petition, page 39, your lordship will come.
That time they have the that particular
But
document.
why the application was not filed, my lord? Because
February 2021, they
Yes.
got the document.
And application was filed in 2023, my lord.
Has the suit proceeded thereafter? In the meantime,
They did no, my lord.
you see, as I said, we are not here to strangle the alcohol. Has to proceed as fast as possible. Interference here or there unnecessarily only delays the proceeding. They have not, the trial court did not reject it on any other ground. Said that he never mentioned that these documents are in possession of somebody else. This would be only required if you ask for a summons under Order 16 Rule 6. He's not. He's saying, now I have the documents with me, kindly allow me to produce it. That's all.
That was after the filing of first application, my lord, where the PW was filed on 2017, my lord.
Yeah.
After that, they have filed this application, my lord.
No, at that point of time, he filed an application that asking that the direction be given to the RBI for production of these documents. That application was rejected by this court on 25/2/2020, and against that he filed the revision application. When that revision application was filed during the pendency, he liquidated the loan. And after liquidating the loan, now he has got back the documents he wants to produce.
That was the second application, my lord. First application filed on 2019, my lord. First revision petition. This is the third revision application, my lord.
Now, is this, you see, what is the reason? Let's see.
And from 2017, my lord, this suit cannot proceed, my lord.
Huh?
From 2017 onwards, my lord, at the PW stage. The same suit is pending for PW stage, my lord. Now it is 2024, my lord. But this reason or that reason, my lord, they are, my lord, always.
Did they file an application earlier saying that I have the documents with me, I want to produce?
No.
This is the first step. Therefore, now the things have changed. He has got the documents with him. Don't you think that a matter needs to be disposed of early so that the court can proceed with it? Unnecessarily delaying the suit is not going to help you. You also have a counter.
I have also counter. That's why, my lord.
This is an application under Article 2 to 7 of the Constitution challenging the order dated 10/7/2023 passed in title suit number 679 of the 2022, whereby the prayer made by the petitioner herein to produce the originals of Exhibit 1, 16, 17, 20, and 21 was rejected by the learned trial court. Before further proceeding, this court finds it very pertinent to observe that Exhibit 1 is the sale deed number 7628 dated 5/9/1967. Exhibit 16 is the Jamabandi of Patta number 73 of Dag number 117. Exhibit 17 is the mutation order dated 33/1979 passed in mutation case number 836/78/79. Exhibit 20 is the no objection certificate dated 17/4/2000 issued by the Guwahati Metropolitan Development Authority to the plaintiff. And Exhibit 21 is the site plan approved by the GMDA on 7/4/2000. It is relevant to take note of that on earlier occasion, the petitioner herein as plaintiff had filed an application under Order 16 Rule 6 for production of those above mentioned exhibited document. By issuing summons to the Central Establishment Section, Housing Loan Department, Reserve Bank of India, on the ground that the originals of those documents were lying with the said authority. The said application, however, was rejected by the learned trial court by an order dated 25/2/2020. Being aggrieved, the petitioner had approached this court by filing a civil revision petition (IO number 86/2020) challenging the order dated 25/2/2020. However, during the pendency of the said proceeding, the Reserve Bank of India had liquidated the loan in the month of February 2021, and the said original documents which have been marked as exhibits 1, 16, 17, 20, and 21 were returned to the plaintiff. It is under such circumstances the CRP IO number 86/2020 was filed. It is under such circumstances CRP IO 86/2020 was withdrawn with the liberty for filing an application before the court for exhibiting those original documents. Accordingly, the said application was filed, which was numbered as petition number 448 before the trial court. The learned trial court, by the order dated 10/7/2023, rejected the said application in view of the earlier order passed by the learned trial court on 25/2/2020, and further observing that the petitioner did not mention and further by relying on the order dated 25/2/2020 passed by the learned trial court, and on the ground that the plaintiff had failed to show due diligence to adduce the originals of the aforesaid documents at the time of filing of the evidence on affidavit. It is under such circumstances the instant application has been filed under Article 227 of the Constitution. I've heard Mr. O.P. Bhatti, the learned counsel, appearing on behalf of the petitioner, and Mr. Siladittal, the learned counsel, appearing on behalf of the respondent. Mr. O.P. Bhatti, the learned counsel, have submitted that the learned trial court completely misread, had completely misconstrued the provisions under which the present application, being petition number 448, was filed. And the same had nothing to do as regards an adjudication to an application which was already disposed of in terms with, which was filed in terms with Order 16 Rule 6. He further submitted it is on account of the leave which has been granted by this court, the said application was filed. In addition to that, the learned counsel further submitted that the leave was granted by this court to file an appropriate application even after the filing of the evidence by the plaintiff. And as such, the learned trial court ought not to have rejected the said application on the ground that the said application for leave was not filed at the time of filing of the evidence on affidavit. On the other hand, Mr. Siladitya, the learned counsel appearing on behalf of the respondent, submitted that the petitioner herein is only delaying the adjudication of the suit, and in the process have delayed the adjudication of the counterclaim which have been filed by the respondent herein as defendants. He submitted that admittedly the plaintiff have received those documents in the month of February 2021, and there has been no diligence or explanation as to why in the year 2023, that too after a lapse of 2 years, the said application was filed.
16 months, my lord. 16 months.
16 months, almost 2 years. The said application. He therefore submitted that this is a fit case for the rejection of the application, the instant proceedings, dismissal of the return with cost. I've heard the learned counsels appearing on behalf of the parties and have given due consideration to the respective submissions. From a perusal of the materials on record, this court is a bit surprised at the manner in which the learned trial court have passed the said impugned order, inasmuch as the learned trial court had laid emphasis, inasmuch as the order reflects that the learned trial court was swayed by the order passed by the said court on 25/2/2020.
Not by the state court, but at that time the case was taken. It is the senior.
That is that trial court's order. Was swayed by the order dated 25/2/2020, which was an order passed in the proceedings under Order 16, Rule 6. This court further is also perturbed by the fact that when the leave has been granted by this court to file an application on the basis of the understanding that the application, on the basis of the understanding that the petitioner have already received the original documents and such application was filed, the learned trial court ought not to have rejected the said application on the ground that the petitioner herein did not file those documents at the time of submission of his evidence on affidavit. Accordingly, this court, therefore, sets aside the order dated 8/10/7/2023 and direct the learned trial court to permit the petitioner to adduce the evidence of Exhibit 1, 16, 17, 20, and 21. This court, however, makes it very clear that the permission so granted by this court shall not touch on the admissibility of the said documents, which the learned trial court shall adjudicate at the trial of the suit. Next. This court further takes note of that by an order dated 13/9/2023, the further proceedings of title suit number 679/2022 was stayed. The said order stands vacated and the parties are directed to, and as the parties are duly represented, they are directed to appear before the learned trial court on 25/2024 24. And the learned trial court shall proceed with the adjudication of the suit by taking into account the above directions and observation and in accordance with law.
No further adjournment, my lord, is there regarding.
Huh?
No further adjournment is
Yes,
regarding,
I am
because
not going to take
during
any kind
filing
of
the PW, my lord, they have taken 3 adjournments.
So,
After
you ask them. It is, I have nothing to say on this. It is not a part out here. Otherwise,
that was
tomorrow
only
the
delaying
law,
the
trial courts will say that they go against A and he comes and the court passes an order in C. You have all liberty.
obliged. Sir.
Yeah, district judge, na?
District judge note.
Both the petitions are taken up together for disposal, taking into account that the petitions arises out of taking into account that both the petition seeks the transfer of MAC case number 1347/2021 pending before the Learned Motor Accidents Claims Tribunal number 3, Kamrup Metro at Guwahati, to the court of the Learned District Judge Sibsagar, who is also functioning as the member MACT. This court have duly taken note of that the accident took place within the district of Sibsagar. Both the claimant as well as the owner of the vehicle are residents within the district of Sibsagar. It is also very pertinent to mention that observe the submission of Mr. appearing on behalf of the petitioner in the claimant, to the effect that the lawyer who was engaged was instructed to file the claim proceedings before the court at Sibsagar, but the lawyer filed the application out here at Guwahati, and it is on account of the said mistake the instant proceedings had to be filed. Taking into account the above, this court is of the opinion that this is a fit case for transfer of MAC case number 1347 of 2021 from the court of the Learned Motor Accidents Claims Tribunal number 3, Kamrup Metro at Guwahati, to the court of the Learned District Judge Sibsagar, who is also discharging the functions of the MACT as member MACT Sibsagar. The as the parties are duly represented, the parties are directed to appear before the learned. This court further vacates the order by which the further proceedings of MAC case number 1347/2021 was stayed, and directs the parties to appear before the Learned District Judge Sibsagar on 10th of June 2024. Written statement of I can like it the registry shall inform both the court.
Obliged.
This court has perused the office note dated 24/4/2024. And from the perusal of the state office note does not reveal as to whether the appellant have received the notice dated 3/12/2019. The registry shall duly intimate the said respective party that the registry shall make necessary inquiry and inform this court accordingly and apprise this court accordingly within 7 days. List the matter again on 13th of May. Yes, Mr. Chaudhary.
Lordship, as per office note dated 29/4/24, is appearing for the
Just call it
number
1.1, 1.3 and 1.4.
You are paying for?
1.1, 1.3 and 1.4.
And what about 1 and 2? 1.2?
1.2, otherwise they're all brothers and sisters.
Your brother?
Sisters.
1.2.
5 for fun. Yes, I can.
You can appear.
Yes, I can.
Where is 1 point? There's no 1.2 business. out here.
ABC.
ABC actually.
Actually, it's
Yes.
ABC and D.
Then what is this 1.2?
ABC.
1B.
1B.
You are
1A.
paying for 1A, 1C and 1B.
1B.
Yes, Lordship. We have filed Wakalatama for 1A, 1C and 1B.
Why you are not paying for the son? Something you don't have good relations.
I don't know, Lordship.
Maybe never know. The brother may not like it. The sister may.
Maybe.
That's why separate Wakalatama.
Tell me one thing. Whether the brothers, they died here, na? This Anil Chandra Devnath died here. In appeal state.
No, Lordship, the very initial stage expired.
Anil Kumar Devnath.
Anil Kumar Dev.
Then they file a joint written statement.
Yes.
They-
But the fact is that, Lordship, here in this case, the substitution has not been made. So I filed an application for striking out the name of the Anil Chandra Devnath and for incorporating the name of the legal heir.
It
During
was not
pendency-
substituted.
pendency of the original case,
It was not substituted.
that was substituted. But due to oversight at the time of filing of this present appeal, the names of the legal heirs were not this,
But
And-
anyway, you corrected that.
exact.
That has been allowed.
That has been allowed.
No, I'm asking you whether that matter
Yes.
in the trial court, the legal representative of Anil Chandra Devnath
Yes.
filed a written statement.
No,
It went ex parte.
not expert Lordship. Initially, this Anil Chandra Devnath written statement was filed by the Anil Chandra Devnath. During
Okay.
pendency of that, it died.
Fantastic. Now he filed alone.
Exactly. By the respondent. Is there, Lordship?
Did he file alone?
Lordship, it is there in the memo of appeal.
Then who filed an appeal?
The Anil Chandra Devnath, the opposite party number 3, Sunil Chandra Devnath, and Gauranga Chandra Devnath. The three filed the joint written statement. It is at page number 12.
Okay, now what about the
Anil
appeal?
Chandra Devnath filed the
Who filed the appeal?
filed the appeal by the applicant, Amulya Devnath. Amulya Devnath filed the appeal. He filed the
First
application.
appeal.
First appeal.
First appeal.
Yes, testament.
There who appeared on behalf of the legal heir?
Legal heir, she is appearing for the legal.
In that proceedings also.
In that proceeding, Lordship, the substitution was there.
Where is the substitution again? He died in the suit.
Exactly, Lord.
Then where is the
pendency of
substitution?
during pendency of the suit, the Anil Chandra Devnath was substituted. So legal heirs
So-
appeared in this case.
So the appeal must have been filed against the legal heir.
Exactly, Lordship. That mistake was there. And subsequently, when I came to know about that, I filed an application for
We are in the second appeal, Mr.
no,
Counsel.
Lordship,
No,
this
this is
testamentary
This is
appeal.
the testamentary appeal.
Testamentary appeal, Lord.
Okay, now. And what is this 1.1, 1.3, 1.4?
1 A, B, C, and D, Lord. They are the legal heirs of Anil Chandra Devnath, who is the defendant number 1 in the original testament.
And what about the others?
Others, Lordship, there is the office note with regard to that. It is on 9/3/2017.
There is a-
Return answer. Respond number 1 with regard to respond number 1, return answer.
Now, what is this IA for?
IA
Order
for
one
this
rule
order
10.
1 rule 10. for striking out the name of the respondent number one and for incorporating the name of the legal heir.
Of
Respondent number one.
correspondent.
Four respondents.
Who are those?
They are the sons and daughters of the widow of respondent number one. Sunil Chandra
So
Dev.
why notice has to be issued in this application? This should have been allowed on the first day.
Exactly, Lord.
In the state through, there was an appeal, you made that mistake.
Exactly.
So that needs to be corrected.
Correct.
Simple thing.
Yes.
So this is an application. In fact, that should have been not an order 1 rule 10. It has to be a correction application.
That means for impleading, I filed an application.
How do you implead them? You can't make you can't implead
Yeah, exactly.
somebody. This is an application filed by the applicant, who is the appellant in the accompanying test appeal number 3 of the 2016, wherein inadvertently the name of the deceased appellant, respondent number 1, namely
Anil Chandra.
late Anil Kumar Devnath,
Yep.
was mentioned. In fact, it is the admitted fact. Fact from the admitted fact, it is apparent that the said Anil Chandra Devnath expired during the pendency of the said test case,
Misprobate.
misprobate case, and he was duly substituted by the his legal representative, whose names appear as 1A, 1B, 1C, and 1D to the application, and more specifically stated in paragraph number 5 of the application. This court, on account of a mistake which has been committed inadvertently, condones the same and allows the instant application, thereby permitting the applicant herein to file a fresh memo of parties before the registry of this court within by 6/5/2024. The instant application stands allowed. The registry shall, on the basis of the fresh memo of parties, make necessary correction in the test appeal number, accompanying test appeal number 3/2016, and list the same and also update the same in the CI. The interlocutory application accordingly stands allowed. Now, it cannot be one test appeal to the up, but it is non-appears on court. Appeal is a matter of right, isn't it?
Yes.
Or no?
Yes.
No stay. Or your appeal was
My
dismissed.
application. Practical.
This the list the instant appeal for admission, along with after making new corrections in terms with the order passed today in IA Civil 32223 of 2018.
Problem.
On the data 6/5 he is going to get done. Then on 10/5.
Here in this case,
Yes,
there's an
we have
office-
not taken notice steps upon the
Lordship, they
respondent
have
number 1
left.
to 5.
Actually, this respond number 3, 4, and 5. They have left the particular page. Already communicated, not been able to start in the present address. It will be taken up to it for the pickup. The delay of only 15 days.
Can we dismiss it?
15 days. Yes.
So, give me a good way, then you are safe from taking steps.
Of this address the left. Actually, we have not.
2019, we
Yes,
have
Lord,
5 years have gone by. Till now, you have not been able to complete the steps, and you are making this excuse. Give me 4 days. You are not interested at all. An appeal has not been admitted because of the fact from 2019 the steps have not been completed. So give me a good reason as to why we should not dismiss it.
Kindly keep 1 week time. In the meantime, I will try to 13th day. Otherwise, I will file an application for striking out the name. Because one, with regard to the respondent number 1, the service is complete with regard to it. But other respondents, they have already left. So I will ascertain the correct address.
You are a plaintiff.
I also think
You should file a suit
for this declaration of rightful interest on the basis of a mortgage.
against whom?
Yes.
Against whom?
That was dismissed. Preferred an appeal also.
Against the defendant.
Exactly.
All are defendants.
Exactly.
Now you want to strike off 2 to 5. Now if you strike off 2 to 5, then what remains?
Difficulty is there, Lord. Then also
Striking out 2 to 5 means the decree which has been passed, thereby dismissing, and if it is conjoined decree, will dismiss the appeal. Do one thing, that is the best way. We strike out at your submission, we strike out 2 to 5. We condone the delay, then dismiss it on that.
difficulties are.
Give me a
Kindly give 1 week time.
Mr. S.P. Chaudhary, the learned counsel, appearing on behalf of the petitioner, appellant, applicant submits that he may be given a last opportunity of 7 days' time so that he can get the proper address and take steps upon the respondent hearing. So, this court direct the appellant, the applicant, take steps upon the respondent. Number 1, to press steps upon the respondent by way of registered as well as mutual on or before 10th of May 2020. If such press steps is not taken, matter be listed on 15th of May 2024, on which date this court shall pass orders against the petition applicant.
In the correct address, actually the address is there in the court address.
Whatever you do
No,
whatever
the
you
difficulty is that if I take a step in the correct address, and since it is not there in the court title, it will not be allowed.
the correct.
In the correct.
Mr. S.P. Chaudhary, the learned counsel, submit that the steps earlier taken upon the respondents could not be effective on account of the address being insufficient. He submits that he may be permitted to obtain the proper address and take appropriate steps with 70. This court have duly taken note of that the instant case notice was issued in 2019 and almost 5 years have passed by. So, under such circumstances, this court fixes the matter on 15th of May 2020. This court directs the applicant to take steps upon the respondent in the correct address on or before 10th of May 2024. It is made clear that if no such steps is being taken, the matter will be listed on 15th of May 2024, on which date this court shall be constrained to pass appropriate orders in the instance.
I could have put it three, but did it. I got prepared a beef. Last evening, my son had eye problem that I had PTB.
Your number?
43, hearing. I have to hotel.
43. What is that matter about?
Here, other than say I was ready.
What is the matter about?
For against the dispute for dispute for order 9 rule 13 CPC, then misappeal was preferred and misappeal allowed. Against that order, present division petition preferred by the mind.
Order 9 Rule 13
Yes.
was
Along with
rejected.
presidential petition also, miscase also.
So, some of a hearing.
Yes. Final hearing.
So what is there to hear?
Other than today,
We allow the application or dismiss it.
it apply yet. So process may be decided. Other than today, any date.
Let the matter reach. You go. I'll take care of it. If it is to be dismissed, I'll dismiss it. And if it is to be allowed, then I will give you an opportunity of hearing.
No, it's okay. But my response.
Huh?
I'm responding.
Understood. If I have to dismiss you, your presence is not required. If I have to allow, your presence will be required. So then I will hear you. I'll give you an opportunity.
Fine.
Because I don't entertain
I'm
mentioning
waiting
at
for
this
the
hour.
till turn.
You go. I'll take care.
May please your lordship. Lordship, I am appearing for the respondent number 1. The service has been completed.
Where is the appellant?
Appellant was absent on the last occasion also, lordship. Its IA is for continuation of delay of 23 days.
What was the decree? What decree was passed? Then arrested.
I don't have the copy, lordship. I only have the IA.
No, you have been asked to appear. What was the matter about? Don't know anything. Don't tell. Because this court had duly recorded that an IA is required to be filed.
For substitution of lordship.
Respondent number 1.
Respondent number 2 expired.
And he has not appeared against the two. Stood for partition. None has appeared on behalf of the applicant. It further transpired that on 5/8/2022, this court had duly recorded that the respondent number 2 had expired. But till date, no steps have been taken. This court fixes the matter again on 13th of May 2024. So in the circumstance, the applicant is not represented. This court would have no option but to close the instant application for non-petition. Please support. Yes, what are the
My lord, section 14 application, my lord. The delay is 489.
for
89.
Substitution of,
Your lordship may come to page 8, my lord.
substitution of,
Substitution.
Respondent number 3 and 4, 3.
4, 3. And this intimation was given to me by the other side in this honorable court.
My lord, respondent number 3 expired on 1/7/2021. And 4/3 Zonali Court expired on 30/9/2021.
In para 2, my lord, specifically I have. The during the pendency of the para
para 2 of what?
my application.
My lord, the copy has been served on me this time itself. Today itself.
You are appearing for whom?
1 and 2. Respondent number 1 and 2.
Who died? 3.
Yes. 3 and 4. 3.
3 and 4.
4.
Yes.
We have to issue notice. Has the notice been issued?
No.
No notice.
Notice what has happened. You have not issued notice.
My lord, there
2, 4, 1,
are
4.
two.
You are appearing to 4146.
Respondent number 1 and 2.
Who is appearing for 41246?
E. Mandal advocate is appearing for others.
So they are duly represented. Hello. How did you know about the death during the
My lord, in
pendency?
para 2, because it was intimated by my learned brother in this honorable court.
When?
Para 2 on
Para 2 of what?
my petition under order 22.
Now order 22 is not
Yes,
done.
on
I will
22,
go to order 22. First you have to say it in your
Yes.
application.
Because in application para 2, my lord, on 22/9/2020,
Where?
I came to know at page 10.
Where is that application? Where have you mentioned for condonation of delay?
Delay, in
Nothing is there.
this petition, I have not mentioned about the condonation.
Oh, no. This is filed within time.
No.
From the date of knowledge, my lord, it is filed within the time because I was intimated on 22/9/2020. But when they died, I was not aware of this fact, and accordingly, my lord, this application.
You have filed under order 22 rule 2. How is it possible you file under order 22 rule 2? It has to be under order 22 rule 4. Okay. Now if you see order 22 rule 4.5, it says that even if there is a delay, you have to explain by filing an application. You have not filed. So you dismiss that application.
In that case, my lord, I will file the condonation petition.
You are not filed.
I have not filed, but now still I can file it, my lord.
Date of, what is this time is given? This is 3 and 4. Date of knowledge. It is not from the date of knowledge. Is it from the date of the knowledge?
It is actually, it is not for the date of knowledge. But so far, my knowledge is concerned. my
Your
lord,
knowledge, we are not bothered. That may be a ground for explaining by filing an application under order 22 rule 4.5.
All right, I will file that.
The learned counsel appearing on behalf of the applicant submits that he may be given 3 weeks time for filing appropriate application, explaining the delay in preparing the application for substitution of the legal representative of the respondent number 3 and 4. 3 and 4.
3 and 4, 3. 4 within bracket 3.
8.
3, 4, 3.
Roman 3. Respondent number 4, 3 and 4 bracket 3. Yeah. What is the delay?
Morning, I made a mention.
How much?
Lordship, there's a delay of 520 days.
520 days. What is the reason?
Lordship, the reason is that the plaintiff, the appellant, he was suffering from certain illness, due to which he was restricted. Her movements were restricted. And there is a doctor's advice in para 3 of the application, Lordship. The petitioner has stated that he has been suffering from certain illness, and in Annexure A, there is a doctor's advice which the doctors had advised her to
Where do you stay?
in Gwalpur. She could not travel to Guwahati to meet the engaged counsel. Thereafter, Lordship, in 26/10/2018, she recovered from her illness, and there's another fitness certificate issued by the doctor, after which she met with her engaged counsel in Guwahati, but the counsel informed her about the
What is the
expenditure.
decree part?
Okay.
What decree is this? Is a suit for what?
Lordship, it's regular second
For what?
for against the judgment and order passed on 5/4/2018 in title appeal number 7 of 2016.
Then
Declaration of
but there is no explanation. Prior to that, after 26/8, 26/10/2018, there is no explanation.
Lordship, in para 4,
Uh.
In the sixth line from hence the petitioner till 5/1/2020 could not arrange necessary expenditures for
Who filed the
filing
suit? Who filed the suit?
Lordship, the
Did you file the suit as a pauper? Huh? You filed the suit. Then and how are you surviving?
Lordship, currently the plaintiff is an unmarried and unemployed.
Where is your mother?
Lordship, the mother Sir, as of today, is married to some other person.
Hmm?
To some other person after her separation from her father. And her father was after separation with her with the petitioner's mother, and she married another person with whom he had two more.
Who are the defendants?
Yes, perfect.
Okay,
And
now
her
understood.
mother,
Ah.
Lordship, she married some other, another person, and she, as per their as a contention of the petitioner, Lordship, she was disowned by her mother, and now she is seeking a declaration that she is a child of her father, legitimate child of her father. But
the mother has divorced.
yes, sir.
What does the trial court hold? As regards the issue number 2, you are not married.
No, Lordship.
Exhibit 2 is only a photocopy.
Yes, but the original was could not be recovered from the card.
Did you call for?
But that time,
But Mr. Counsel, this court is not satisfied with your explanation after 2018. I'll do one thing. Your senior is there, na? So
yes, but
I won't dismiss it in your hands. I'll dismiss it in the hands of your senior. Okay. The learned counsel appearing on behalf of the applicant submits that his senior, Mr. R. Sharma, on account of
annual Shraddha ceremony of the state father.
of the death anniversary of his father, could not attend the court today. This is the matter again of 22nd of May 2024.
Tell you.
Mr. In the meantime, the applicant may file additional affidavit in the application to the application filed by the file for seeking condonation. 15.
Yes, last
Who died?
Respondent number 7.
responded. I submit the detailed head of the
Then why haven't you filed an application?
Lordship, we have just get over the details of the legalized just today.
When?
Just today.
Mr. Learned Counsel appearing on behalf of the applicant submits that the copy of the next of the kin of the legal
Details of the
representative of the respondent number 2 and 7 have been provided by the Learned Counsel appearing on behalf of the other respondent today only. He therefore submits that 3 weeks time may be granted in the behalf. Taking into account the above, this court direct the matter to be listed after 4 weeks. Without stating anything as regards the limitation in filing of that. Limitation filing. Yes, what is this?
I thought content of detail, my lord.
How much?
My lord, 560 days as per calculation of date.
500?
16 days.
Why?
As stated in para 3 of my petition, my lord.
What type of case is this?
My lord, the case is that, my lord, the defendant, my lord, respondent, claiming as a wife of my father. Actually, she was maid, my lord.
So are you saying that that person concerned, that okay, A Hawk, you did not entrust him to A Hawk is the son.
My lord.
Is the son of the earlier advocate.
Yes, sir.
And
A
he
Hawk
did
is
not
the son of A.K. Fazlul Haq advocate.
So he did not inform you.
Right.
Okay.
Well, actually, the brief was in the hand of A.K. Fazlul Haq.
He died.
He died.
And thereafter he did not inform. Did the
Actually,
did
there is no correspondence.
A
with
Hawk sign the wakalatnama in
Right.
that appeal?
that. Most probably at that time he was not an advocate. That
If
is
that
my
be
assumption.
so, you have to say that A Hawk appeared without authorization.
And that I cannot.
Find out, because we are not going to do it on the basis of blaming the advocate. I'm telling you. If you find out that, then file a AR to the bar council. Then only I'm going to take it up. Upon perusal of the application filed under Section 5 of the Limitation Act for condoning of the delay, serious allegations have been made against the counsel, Mr. A. Hawk, who conducted the appeal on behalf of the applicant. This court inquired with the learned counsel appearing on behalf of the applicant as to whether Mr. A. Hawk, advocate, was duly authorized by executing a power, by executing the wakalatnama in his favor to appear in title appeal number 27 of 2017, and or as well as to whether Mr. A. Hawk, advocate, had appeared without authorization. If the fact is that Mr. A. Hawk had appeared, advocate had appeared without authorization, it would amount to a serious misconduct on the part of the said counsel. Under such circumstances, this court grants 4 weeks' time to the applicant to make an appropriate inquiry and apprise this court by filing an affidavit. A condonation does not happen with lawyer being paid. Yes, Mr. Bora, why you are not going? Go. Don't worry. Go. Yes, what is this I for?
We need to take fresh step in response of respondent number 2, madam. Respondent number 2, madam. Finally, 1 week time will be done.
Why haven't you taken steps?
My lordship, we don't know that that was reached to Kojima court, my lordship. We'll take within 1 week, my lordship. It is our part of mistake, my lordship. We'll take within 1 week.
First of all, you don't appear when the matter is listed before the Lozima court. Then we impose a cost of 5,000 upon the lawyer. No, one has to be responsible because this is of 2023. The order is being passed. Are those orders, are these Lozima court just for the sake of it? Then why, when it was shown in the cause list, why didn't you appear? You were directed to take steps within 2 days. Within 7 days, you did not. Thereafter, the matter comes up before the Lozima court not once, twice, thrice. But then also you don't care to appear. Then, and this court should grant you any further time. We'll strike out the name of the respondent number 2. And then proceed. Yes, tell me what is the ground for delay of 651 days? If we dismiss it without going into all these things, you need not take steps. Tell me. Was not aware of the aforesaid order dated demand passed by very recently tried to take possession over the land. Why? You could not know. So the death of the father of the some vested interested person came to accepted to get money, either to sell the land minus applications. He also filed a guardianship case before killing a law and obtained the impugned guardianship order dismissal. Was not a fair of What is your age?
Now, the time of filing is 18 years is given. I'm daughter of the deceased.
Then? What has happened thereafter?
The mother claimed for the property, and as per last year, they sell the property, my lordship, the land.
Have they done anything till now?
Yes, yes, my lordship.
Have they done anything till now?
As per instruction, last instruction, they sell the land.
But what remains in this proceeding? There was an order passed by which somebody was appointed as the guardian. But the guardianship order is only till a particular period, till a person attains the majority. You have attained the majority in 18.
Yes, sir.
Then what remains in this proceeding?
They did not, during that time, they did not.
Let's see the impugned order. Petition is represented in the petition has been What is the name here? Nazreen Akhtar Bormia. As mentioned in the final. They also said the petition. What is there now to challenge this? Nothing remains, because what you need to do upon becoming a major, you need to challenge it by if you have a challenge once any sale. Makes no sense. Who is appearing? You are the person.
I'm for the respondent number 4, my lord.
You have sold the land.
My lord, I have to take instruction, my lord.
Don't take instructions. Who is respondent number 4? Alimuddin Bormia. There is performer. You do one thing. This makes no sense because now you have already become a major.
Yes, my.
So you need to challenge that whatever sale has been made. And if you don't challenge it within time, nothing remains.
Yes, my lord. Challenge that order.
And what is the ground of challenging that order? This order? The main order, why are you challenging it?
They passed without looking into the merit or whatever. They have not taken into the all the other aspects, my lordship.
You were a minor then.
At that time, we are minor.
When that order was passed,
Yes,
you were
sir.
a minor.
Yes.
Any sale has happened?
As per my instruction is on last instruction, sale has happened, my. As per, but I'm not sure about it.
Who is Jamal Uddin Bormia?
His son.
Huh?
Son, there are son, daughters, but they're of the deceased.
Were they parties in that proceeding?
Yes, yes.
Who has filed that case? Interesting.
I am from the daughter side, Nazim.
Understood. You are the daughter. That is why I have very well understood. I'm not on that. But how are these other people are made parties? The application was filed by one Fatima Begum Borbhuya.
Yes, my lord.
Why are you making the all other people a party?
All of them
Jamaluddin
together
Borbhuya, these are opposite parties.
all of them together have appointed her as a guardian, my lord.
My lord, there is a nexus between petitioner and the respondent number. Petitioner Narjin Akhtar is the daughter of Abdul Latif, my lord. And
Abdul
Latif, my lord. And yes, my lord. And Fatima Begum is the
petitioner
wife
is the
daughter of
daughter.
deceased, my lord.
And petitioner is the daughter or what?
A daughter of Abdul Latif, my
No,
lord.
the appellant out here is the daughter.
Appellant, my lord, yes.
But the person who took the guardianship was the mother.
Mother, my lord. When he failed in the case, my lord, then he himself, by making a conspiracy, my lord, the instant his case was filed by her daughter, my lord. That is the case.
You are the daughter of Abdul Latif.
Yes, my lord.
And the petitioner Fatima
mother.
Begum Borbhuya is your mother.
Mother, my
Is she your mother or not?
mother, my
Now what are you alleging? That she did everything without the interest.
yes, my lord. Without concern, that everything is done by himself, my lord.
Huh?
He have done by himself. He have sold the land by taking guardianship and everything. He has done by himself, my lord. Even my part of was also being sold of the land. I also, as a law, I have also right about my parents.
Understood. That can be said. So by the guardian, but subject to the limitation. Keeping this pending out here, with the order being set aside, what is wrong with the order? You see, the court having appointed you, appointed his mother as a party.
My lordship, can it be fixed on Monday?
Why?
Well, I would take full note of it and I will come, my lord.
You take it, huh? Because I think, you see, only worry is if you withdraw, would it affect the sale? And thereby debarring you from challenging the sale.
Yes, ma'am.
Otherwise, this court, taking into account that she was the mother, they can the guardian can very well sell for the benefit of the minor.
Yes.
Now, if the guardian can sell on benefit of the minor can challenge later upon attaining the majority. The sale. That is permissible. But unnecessarily keeping the matter delayed for such a long time would further not be in your interest. Let's have it on Friday.
No, my lord, on Monday, my lord.
Why Monday?
Monday, because the
Good day.
senior counsel who is there.
Who is senior counsel?
And Islam is out of station.
I don't require
will
the
be on
senior.
Monday, my lord. I will surely come with the file.
Okay.
Deeply obliged.
Good. If it is a senior counsel, then I can dismiss it on it. I have been more considerate because it was. Anyway, it's the matter again on Monday. And at consideration as to whether the instant appeal apply without a challenge to the sale made by the guardian appointed without being challenged. Yes, what is it?
Lordship, I will be purchased to send to party
Huh?
regarding the justice certificate.
Taking into account the remand, this court is the order dated remand passed by the tribunal in which guardian till the next. Yes, then what happened? You have taken steps?
Yes, Lordship, but
What
affidavit we have not filed.
Huh?
We have not filed the affidavit.
It's the matter here. When did you take steps? No affidavit regarding Dusty has been received as yet. Neither ID card here. Why no Dusty? I granted you a stay because of the Dusty. And you have not taken Dusty. vacate the order. Now, this court, by an order dated 14/9/2022, have directed the applicant to take service steps upon the respondent by way of the stick, in addition to the usual process. And it is under such understanding, this court, and it is on the basis of the said understanding, this court had stayed the impugned order dated 27/6/2022 passed in by the additional district judge Srirang in Miss Guardianship case number 1/2021 till the next date. However, till date, no steps have been taken by way of the stick. In spite of almost 2 years having been passed. This court fixes the matter again on 19th of June 2024. The petitioner is given a further, the applicant are given a further direction to take steps by way of the stick, in addition to the stick. On 24th of July 2024. The applicant is further given the is further directed to take steps upon the respondent by way of the stick. In addition to that, the applicant is further directed to take steps by way of registered as well as usual. The dusty service has to be routed to the registry of this court and an affidavit of service be filed before this court. The order dated 14/9/2022, by which the order dated the impugned order dated 27/6/2022 passed by the additional district judge Srirang in Miss Guardianship case number 1/21, which was stayed, is hereby vacated.
So as per office note, that is 1/4/24. But not, someone has been discharged upon all the response.
What is this? Why the matter has come? For stay? Here is it too. Service complete.
On
You are appearing for?
I'm for the respondent number 1.
We have received the summons on behalf of everyone.
That I don't have.
That is what is there in the protector. Who are those? 227.
They are related, my lord, brothers and sisters.
Huh?
They are related brothers and sisters.
From the perusal of the office note dated 1/4/2024, it seems that the service is complete. Further to that, LCR has been received. Accordingly, the matter be listed for hearing. I cannot take it. This is an application under Order 41, Rule 5 of the Code of Civil Procedure for stay of the judgment and decree dated 31/5/2019 passed by the judgment and decree dated 16/7/2022 passed by the learned civil judge, entitled appeal number so and so. 26th of 2019. Taking into account that the appeal has already been admitted by formulating substantial question of law, and the parties are duly represented, and the LCI has been received, for which this court have already fixed the matter for hearing in the usual court. This court deems it proper that the interim order, which was proper to stay the judgment and or decree dated 31/5/2019, passed by the learned, the judgment and decree dated 16/7/2022, passed by the learned civil judge Logao, entitled appeal number 26 of 2018, till the disposal of the appeal. I sense the court.
Your life.
Yes, what is this?
My lord, this there's not type, my lord, was not located, my
Huh?
but as per instruction, there's no type, my lord, it's unserved, my lord. As per the instruction, my lord, is within the address is correct, my lord. We may be allowed to the service about the no type. And 1 to 4 and 6 to 9 already appeared, my lord, I have said. And regarding, my lord, pro forma response 9, 11, 12, and 14, my lord, they have already expired, my lord.
Then what did you do?
Required some more time.
The learned counsel appearing on behalf of the applicant seeks for 6 weeks time to take appropriate steps. Without commenting on the question of limitation, the matter stands adjourned, which is
That's not time may be allowed to serve.
What?
That's not time may be allowed to serve. Public.
In this case, respondent number 1 to 4 and 5 have appeared. Respondent number 3 expired. And they may be stuck off. Respondent 4 or 5 are
What about
all the
6?
6 is replaced by 7. Etiquette with
Mr. S. Purkaster, the learned counsel appearing on behalf of the applicant, submits that the name of the respondent number 3 may be struck off. Further to that, it is seen that the service upon the respondent number 1, 2, 4, 6, 7, 8, 1, 2, 4, 5, 6, 7, and 8 are complete. It is further seen that the respondent number 3 had expired, and the learned counsel appearing on behalf of the applicant submits that the name of the respondent number 3 may be struck off. Taking into account the above, the name of the respondent number 3 is struck off at the risk of the applicant. Taking, what is the matter about?
22 days delay.
Huh?
22 days.
You are paying for?
For the respondent, my lord.
For the respondent.
Yes.
Now, let us see.
I have no objection.
No objection. Okay. Who is respondent number 2?
I'm appearing for 1, 2, 4, and 5.
Now, who is respondent number 2? Who died?
3.
3. 3 is who?
3 is the mother of respondent number 4 and 5. They have sold out to respondent number 1.
So why you are not making that submission to be struck off? You say that respondent number 3 is duly represented.
So 4 and 5 are the legal heirs. They're already on record.
That is what. Why are you not making that submission? You are asking for striking out 3. You know the implication of striking out 3 at the risk.
No.
I may dismiss it if it is a joint decree.
I have made this submission that they are already on record. 4 and 5.
You never need. Anyway, Mr. This is from the materials on record, from the office note. It repeats that the respondent number 3 had expired. Mr. S. Purkaister appearing on behalf of SD Purkaister appearing on behalf of the applicant submits that the respondent number 3 is the mother of the respondent number 4 and 5. So, taking into account that the respondent number, that the estate of the respondent number 3 is duly represented, so the learned counsel submitted that there is no further necessity of substituting the legal representatives of the respondent number 3. So, taking into account the said submission, the name of the respondent number 3 is struck off. This is an application for condoning the delay of 22 days in preparing the accompanying secondary appeal against the judgment and decree dated 14/2/2022, passed by the learned civil judge number 1, Qatar at Silchar, entitled appeal number 18/2018. This court have duly perused the grounds as assigned in the application and have also heard Mr. H. Das, the learned counsel, appearing on behalf of the respondent who offered no objection. So, taking into account the above, this court condones the delay of 22 days in preparing the accompanying appeal against the accompanying appeal. So, I stands this court. The registry is directed to register the accompanying second appeal. Second appeal, na? And list the matter in the column of Order 41, Rule 11. Good case, that.
Good case. Another case.
Purdi court, they have lost. Purdi court.
Another case, Lordship has already admitted. Same
That
town.
day,
Yeah.
that one.
Same town. Same
Party.
Same. Judgment is a copy, sir.
Purdi court.
Only defendant number 1 and 2 are different.
Again on 13th of May 2024. Mr. S.D. Purkaister shall serve a copy of the memo of appeal to Mr. H. Das representing the respondent, and the registry shall show his name in the court.
Let me look.
23.
Mayor, but
Hmm.
the brief of this matter has been taken away from us. We are no longer the counsel.
What order you are telling? What is it telling? Section 9. Section 6.
Section 6, my lord.
You say that a brief has been taken.
Yes, Lord.
What did you do? Did you give a proper understanding or anything to that effect? Any receipt to the effect? Did you? You can't take over the brief like this. They have engaged you by way of a power of power. That power is like a wakalatnama, which is the wakalatnama is the power of attorney. Now, have you disengaged him by anything? You require to intimate him that here and get his signature, and you are not responsible. Have you done anything? Then you can't say that you are responsible. Are you? Section 6 is what? No stay. Have you got the position?
Yes, sir.
Got the position?
I was already in possession, my lord.
No. Who filed the section 6?
They have filed.
That was dismissed.
That was.
The learned counsel appearing on behalf of the appellant, petitioner submits that the brief have been taken away. This court would like to be apprised as to whether any notice have been given or any documents can be shown which would evidence that the petitioner, the counsels have disengaged themselves from the matter and the file has been taken away by the petition. In that regard, an affidavit be filed. This is the matter again on 25/2024. Affidavit be filed by the counsel.
Prayer was rejected and this court has upheld that order of
Where is
rejection.
that order?
The reviewing order is at page 27, my.
You filed an application for impleading whom?
My lord, one of the sister of Nagendra Sood, who has inherited the
Name.
name, my lord, the name sister of Nagendra, my lord. Her name is my lord Tiroda Nar. She has died, my lord, leaving behind her 3 sons. So they never mentioned in the plaint, my lord, that she existed, my lord.
You are the
We are the, my lord, either the plaintiff and the defendants are cousin brothers, my lord.
you are the plaintiff.
We are the defendants.
Then did you file a counterclaim?
No, my lord. Counterclaim is not there, my lord.
Then why did you file an application?
Because, my lord, the plaintiffs have claimed the right of Nagendra Sood, my lord. Without disclosing that, my lord, he has got a sister, my lord.
Then?
And originally the land belonged to their grandfather, my lord, late Bhuliram.
Then who filed that application? Tiroda Nath. Who filed that?
Defendant number 1, defendant.
Why defendant file?
Because, my lord, we are also the plaintiffs and defendants are brothers, my lord. This is a suit between the family. So if the legal heirs, all the legal heirs are not represented, my lord. Because
then why is that Tiroda not coming and filing an application?
Well, she has died, my lord, leaving behind her 3 sons.
So why are the legal representatives not filing an application?
My lord, I cannot.
They should file.
My lord.
If they file the matter, the court will be bound to look into it. Why is the defendant? He is the plaintiff, is the dominant witness. They may impede somebody or not.
My lord,
now the thing is, in your written statement, have you mentioned that Tiroda that was a party, was one of the legal representatives?
No, in the WS, my lord, it was not.
Not me. So what right do you have to ask for impleadment for somebody?
Being a defendant there, but my lord, since
you are not a counterclaimant.
No, my lord.
So how are you, as a defendant, can claim anything? Ask that in that suit, so and so has to be paid. Why are not the legal representatives of Tiroda Nath or whatever may be come and file an application? Matter will be solved. Then the court will be bound. then res judicata or anything does not come into the picture. Then how are you bothered?
So that's why first,
Huh?
my lord, that application has been filed by a defendant. My
Understood.
lord, that
Anybody who has an interest on the property can very well come.
Well.
Now you want the plaintiff to impeach somebody who does not want that they should be impeached. Isn't that the thing? Isn't it your application misconceived?
my lord, it is, but my lord, since between my lord,
So
brothers,
what?
my lord,
Can't you take a benefit on that?
my lord.
That if a suit has been there, this person can very well tomorrow come and before the court and say that execution cannot be done in view of this because we were not made a party. 47 is directly hit. So you should be happy.
You be allowed to close this.
Huh?
Be allowed to close them.
Fantastic idea. Withdraw the petition. And luckily, that is why your counsel did not appear in the
my
trial
lord,
court
as
also.
per my instruction, my lord, that is my lord not there. He was also hurt, my lord. As
But
per
it has
my-
been said that it has not
yes,
been
my
heard.
lord, court has said that, my lord, but I have asked my lord specifically said that, my lord, both of them were hurt.
Mr. P. Sundhi, the learned counsel appearing on behalf of the petitioner, taking into account that the plaintiff is the dominant witness and there is always a right available to the legal representative other than the legal representatives of Ms. Srimati Kiroda alias L.A. Nath to approach the court. The filing of the application under Quarter 1 Rule 10 was misconceived by the defendant. It therefore submits that the petitioners herein who were the defendants would not like to press the application. Taking into account above, the instant petition stands closed on withdrawal. The interim order passed on 26/4/2023, whereby the further proceedings of petition number 68 of 2013, pending in the court of the learned Murtid number 1 Punitpur Tezpur, which was stayed, is hereby vacated, and the parties are directed to appear before the learned trial court on 1st of June 2024. So further,
My lord, I place two things which are
What?
necessary. Two things. First is that this case is languishing for cross-examination since December 2015. And the defendants time and again are coming out with some sort of application. This is not the first round of application. On similar matter, they had filed an application. That is why I'm placing on record matter. And your lordship ultimately dismissed their earlier civil revision petition, saying that this is not maintainable because by that they were withdrawing their admission, my lord, by way of amendment. What amendment they were seeking? That Kiroda is a necessary party and because of her absence, the suit is bad. When this application was rejected by the trial court, they approached this honorable court, ultimately got dismissal. Now, by way of order 1 Rule 10, again, the same matter has been placed. So kindly look at the conduct, same thing. Either this way or that.
With each submission which I have recorded, I put a death nail into the Kiroda episode with him. Now Kiroda
But
comes up,
new
legal
idea will come to
representative of
them.
Kiroda comes, that is another aspect.
New idea will come, my lord, that let us bring some Kiroda. Because they never disclosed about such person in existence in their written statement. And we all are family. Where from this Kiroda has come? And since December 2015, by one or the other thing.
25.
Yes, what is this?
May I please, lordship, my lord, the civil revision petition in respect of the judgment at page 43, my lord, and excerpt 7, my lord. My lord, actually, the judgment has been passed ex parte against the petitioner, because the concern.
What judgment is this?
My lord, for restoration of possession of a particular property.
Huh?
Yes.
Section 6.
That was the application under section 6 of the specific real estate, my lord.
Suit for specific
Yes, ma'am.
under section 6.
Yes, ma'am.
Suit is for restoration of possession and realization of compensation for damages caused to the defendant. Then what happened? It was dismissed.
No, my lord, that was allowed, my lord.
Okay. Then
Ex parte against the present petitioner, my lord. The petitioner was the defendant in the suit, my lord. And my lord, from the stage of cross-examination, my lord, the petitioner herein, my lord, he was not informed anything by his concerned advocate, my lord.
don't make all these allegations.
No, my lord, that is true. my lord.
No, Mr. Bora, no allegation unless you report it to the bar council.
Yes, I have reported. I have annexed it, my lord.
Show me.
I have annexed it, my lord.
Where?
Page, my lord, page 71, annexure 9, this is the money receipt, my lord. Then page 72 is the complaint and relevant allegation and relevant portion is at page 75, my lord. Specific allegation, my lord. Because the concerned advocate did not examine the one PW and he did not adduce any evidence on the part of the defendant, my lord. Page 75, para 7, my lord.
And what has happened? In the meantime,
my lord,
what has the bar council done?
my lord, after this, we have not received any notice on any kind of intimation, my lord. It was filed on 15.
Bar council is nearby.
Yes, sir.
Find it out. We'll have it on Monday.
Yes.
Tuesday, Wednesday.
Yes.
Find it out from the bar council. What has happened.
Yes.
Mr. T.P. Bora, the learned counsel for the petitioner shall apprise this court as to what transpired in the complaint which has been filed before the bar council against the counsel of the petitioner of the against complaint which have been filed against one Nopo Dotto, the counsel who earlier represented the petition before the trial court, on the next day. This is the matter again on 10th of May.
Hello. 26.
Wait, this one. First, civil evidence petition, my lord.
What? Petition under
227.
okay. What's the order?
Yes. My lord, the petition order starts from 38. My lord, basically, my lord, the respondent was the plaintiff. He filed a suit seeking declaration of his right title interest and recovery of past possession. And the petitioners are the defendants. So when the matter was fixed for cross of DWS, then, my lord, one particular adjournment petition was moved by the counsel duty against counsel of plaintiff. My lord, that is at, my lord, case number 30. For adjournment. Adjournment was granted. Case number 30, my
30.
30. Then petition number so and so filed by the newly engaged learned advocate for the plaintiff side with a prayer to allow him to represent on behalf of so and so. Petitioner has filed along with a wakalatama. So this adjournment was allowed and this was fixed for cross of DW. So after that, what happened? On the same day, they filed a petition for withdrawal of the liberty to file a fresh suit. After the adjournment was granted. That petition, my lord, is start from, my lord, page number 32. So once the petition was filed, no order was passed to the main suit that this petition be registered as a mistake. So we had no idea. Then, my lord, on the same day, if your lordship will see on 31/8/2023, the learned court below. This is the impugned order, my lord, starts from 38. Without even, my lord, giving us any opportunity, my lord, without discussing anything as to whether there is any formal effect or not. Dispose of the state petition, my lord, will find the relevant.
Where the liberty granted?
Yes, at page number 40, my lord.
Where?
Page number 40.
Yes,
This is the reiteration of the entire petition. Then hard peruse petition is allowed for ends of justice. The suit of the plaintiff is disposed of on withdrawal. Now, had it been a case of, my lord, absolute withdrawal, my lord, we have nothing to say. But this petition was filed seeking withdrawal with liberty to file a fresh. That is, my lord, page number.
So will you be satisfied if this court observes that it will be only a suitful withdrawal?
Because, my lord, the prayer portion of the petition contained that
Now the court having not granted specifically,
Yes.
it will be deemed that it is a simple withdrawal. You'll be happy. Will you be happy?
Yes, but date was also correct, but specifically it is not.
Huh?
It is specifically not mentioned.
Therefore, this order has to be deemed as a withdrawal,
That is
simple withdrawal without liberty.
without liberty to fight. That is. But in prayer, my lord, it is
There
that
it was
was
there.
liberty.
Who is the person who filed it? You.
Yes, the plaintiff.
I will plaintiff file.
Plaintiff.
Then if this is not there, unless you correct the record, how can
That
it
is-
perform?
that
The court has to record reasons that
That is-
there has to be a formal defect. The reason when a liberty is to be granted, these aspects has to be categorically mentioned in the withdrawal order to grant the liberty.
Right.
Having not done so, the order has to be construed to be a simple withdrawal. Of the suit.
But
But
the prayer
then-
portion of the petition contained the prayer.
We'll observe it that this cannot be construed to be a withdrawal with liberty because of the fact that the court have not discussed anything. There are two ways out. One is I set aside this file and remand it,
Yes.
thereby giving you the liberty
Liberty to file objection.
object. Or the second is construe this as a withdrawal. You should be happy with this. Which-
First one maybe.
You want the first one.
Because they did not file objection. They did not get
Get it objection.
Therefore, this is an application under Article 227 of the Constitution challenging the order dated 31/8/2023 by which the learned trial court allowed an application under Order 23 Rule 1C, read with 161, 151 of the court to withdraw the suit. It is relevant to take note of that on 31/8/2023, when the suit was fixed for cross of the defendant witness, the counsel appearing on behalf of the plaintiff being recently engaged filed an application seeking adjournment. Accordingly, the trial court fixed the matter on 22/12/2023 for cross-examination of the defendant witness. It further revealed that subsequently an application was filed by the plaintiff for withdrawal of the suit with liberty to refile, which was registered and numbered as Ms. J case number 175/2023. The filing of the said application was also on 31/8/2023, but was filed pursuant to the order passed on the same day, thereby fixing 22/12/2023 as is apparent from the records. However, the learned trial court, that is the court of the Civil Judge Junior Division number 1, Borpeta, without taking into consideration the rights of the defendants to oppose an application seeking withdrawal with liberty, allowed the said application by the impugned order, which is the subject matter of challenge in the instant proceeding. This court have duly taken note of the arguments made by the learned counsel appearing on behalf of both the parties and have given due consideration to the same. This court is shocked and surprised to take note of the manner in which the learned trial court, that is the court of the Civil Judge Junior Division number 1, Borpeta, had dealt with the said application filed for withdrawal of the suit with liberty, without at all considering that there is a right available upon the petitioner, upon the defendants to oppose the liberty to be granted for filing a fresh suit This court also finds it very strange to take, very strange on the part of the learned trial court to entertain such an application and pass an order pursuant to an order passed whereby adjournment was given fixing 22/12/2022 23 22/12/2023 for cross-examination of the deed. Such a practice ought to be deprecated, as the same goes against the very principles of natural justice, which is the cornerstone of all judicial proceedings. Accordingly, this court therefore sets aside the order dated 31/8/2023 passed by the learned trial court in Misday case number 175/2023, and thereby directs the learned trial court to decide the said application after giving due opportunity to the defendants to oppose the said application. This court, by an order dated 4/12/2023, had stayed the further proceeding of and had stayed the order dated 31/8/2023 had only stayed the order. That means the suit was proceeding.
No, but to my instruction, no plaintiff. No suit has been filed.
No suit has
No,
been
no, no,
filed,
no,
but
no.
court-
Is
the
the
suit-
suit proceeding?
Yes.
Court-
Well, date has been given for
because of this court.
What is the next date?
I find out myself.
It has been submitted that in view of the order passed on 4/12/2023, whereby the order dated 31/8/2023, which have been impugned in the instant proceedings, was stayed. Title suit number 71/2017 is presently proceeding. This court, having set aside the said order and having passed the directions to the learned trial court to de novo consider the said application after giving due opportunity to the defendants to file objection, nothing remains in the said impugned said order dated 4/12/2023. The parties are directed to appear before the learned trial court. The suit is presently fixed on so and so, on which date the defendant would be at liberty to file their objection, if any, to Misday case number 1 to the petition filed under order 23 rule 13, which have been registered as Misday case number 175/2023. And as observed earlier, the trial court shall decide the same in accordance with the.
I will find out the date.
Give it.
Hello.
Yes, what is it?
May I, Your Honor? As per office note dated 10 April 2024, as per the process server's report, notice was received by the respondent herself.
What is the case about?
The case is, my lord, the petitioner filed MSC case in Gualpara after 18 years of alleged accident.
Hmm.
So the respondent insurance company filed preliminary objection, and that objection has been rejected by the Honorable Tribunal, Gualpara.
Where is that order?
Order dated 21/3/2023.
Date. Yes, what do you say about the Supreme Court saying that there is no period of limitation?
There is no, in the judgment passed by Honorable Supreme Court, in the case of Purohit and Company versus Katumbi and another, civil appeal number 2555 of 2017, arising out of SLP number, date of judgment is February 9, 2017. That is prior to amendment of MBX. Honorable Supreme Court has said that in this particular case, the petitioner filed application after 28 years. And in this present case, it is 18 years. In Purohit and Company versus Katumbi case, they have filed after 28 years. And in this present case, it is after 18 years. My contention, my lord, is the 1988 MB Act 1988 came into force from 1st of July 1989. And the 2019 amendment came into effect from 1st of April 2020. In between this period, the door is open and anybody can come and file case. But there must be some reasonable period. And plethora of cases are being filed in Gualpada, Dhubri, Borpeta, where from they are finding these injury cases and they are filing case where the insurance company is unable to locate the policy, police records are not available, even the central motor vehicle rules.
And what is the explanation given?
No explanation given, my lord.
Have they filed objection?
They have not yet filed objection here in the before this Lanet High Court. But
not before the trial court?
Before the trial court, they have not filed any objection. Simply our objection has been rejected. They are trying to open the Pandora's box. Now, since the legislative intent is to impose some limitation, they are now finding the back door. Had it been 2-3 years old, it makes some sense, my lord. But it is 18 years, 13 years.
What has happened as regards the service?
Service, the process service report says the respondent herself has received the notice. And with regard to the notice by way of registered post, neither the AD card nor the unserved notice is returned till date.
We do one thing. We see the further proceedings of that proceeding.
Yes, that is the proceeding there.
We see it, and let's await the service, because this is the important aspect. It needs to be looked into
Whether registered
as
AD
to whether an explanation, how far an explanation it can be given. Yes, I have seen the judgment in Purohit and Company. In fact, you next time onwards you produce 2017 4 SCC 783. That is the judgment.
2017.
4 SCC 783.
Flash method. Plethora of cases are being filed, and we have preferred only against 3 CRPI.
Because one thing very relevant is this judgment of Purohit is a judgment of 3 judges.
Yes.
Whereas the earlier judgment is of 2 judges. Dhanalal is 2 judges.
2 judges.
The record reveals the office note reveals that the service upon the respondent have been duly effected by way of the process service report. However, none has appeared on behalf of the respondent. This court, for the interest of justice, grants an additional opportunity to the respondent to appear, thereby fixing the matter on May 21st, 2024. This court further states the further proceedings of MAC case number 339/2021 pending before the MSCT Goalpara till the next day, taking into account that the instant that this court is duly considering the legality and validity of the impugned order dated 21/3/2023, by which the applications were filed by the petitioner for rejection of the claim on the ground of delay of 18 years was Rejected. List record.
Acknowledgement.
Mr. Counsel, can you ask your office to serve a copy of that to the counsel for the claimant out there in that proceeding? Because that proceeding is going on.
Yes, yes.
The counsel for the petitioner shall also take steps of submitting a copy of the instant order along with a copy of the petition before the learned MACT, Walpara, so that the copy of the instant application and the order passed herein be also furnished to the claimant in the said MAC case number 20. Yes, what is this?
My lord,
What is this
yeah,
IA for?
petitioner number 1 died, my lord.
Why?
How
How many?
Yes, yes.
How much is the delay?
Delay is 82 days, my lord. But that though I is filed for condonation of delay, that has not shown in the court list, my lord. But
All are here.
yes, yes.
Then,
That is,
who died?
that is Mohabir Chan Parak. He died, my lord.
Mahabir?
It is IA 1021.
Mahabir Chand
Parak.
Chand had died.
Yes, my lord. His legal heir. He died on 4/8/2023, and this case is filed for impeachment about delays 2 days because the ground is at page number at para 5, my lord.
Why the delay?
My lord.
Why the delay?
Delays, my lord, page 6, para 5. That the above noted petitioner number 1, Mohabir Chan Parak, died on ailment of cancer at Rajasthan, and all the applicants were busy with the petitioner number 1, Mohabir Chan Parak, at his hospital. And on the date dated 4/8/2023, all were busy with the usual activities as the Rajasthan, for which they could not able to procure all the relevant documents in time. That is reason.
What has happened before the trial court?
My lord, that there are also one petition is filed, and that petition is also pending.
Now, what do you want here?
My lord, to include all this.
If I may point out, the substitution application filed in the lower court.
We go into that. Yes, Mr. Fukon.
Hello.
What do you want?
Now, there may be impeded, my lord, here. All are the legal heirs, my lord, of Mohammed Chan Parak. And they will continue this division. They have already given one power of attorney, my lord.
What is this? Page number, what is this 10?
My lord.
Have you implemented your person?
In a trial court, my lord.
Ah.
I have filed a petition, that petition is pending.
Substitution?
Yes, my lord. All everything is filed there, my lord.
Yes, tell me.
Hello. The substitution application that is filed in the court below, my lord, That is rejected on 1/3/2024.
Not rejected, my lord.
I have the
Actually, what happened? Let me start it. The true fact is that that petition was filed, and the petition was filed not by the parties, by the advocate. That's why that petition was rejected, and subsequent rejected on the ground that the proper petition is to be filed, and accordingly, proper petition is filed now. That petition is taken.
Now you want an order in your petition on 5/6/2020, which you filed then. That is your relief you are asking here. We can only ask the trial court to decide that.
Yes, my lord. That petition is not. They have not decided the petition. That is
That
only
is the
granted,
court,
my lord.
the trial court has to, on urgency, decide.
Yes,
That's
my
all.
lord. Actually, what happens is that neither the petition was accepted nor it was rejected. The petition was not accepted there.
Not accepted me.
My lord, that petition 151 petition was filed for interim relief. It was not accepted by the court.
Why?
That is why I have come here.
Why the trial court have not accepted that?
Not accepted, my lord. The petition is here in the CRP 253. Your lordship will find here. That
Page 36.
Page?
Page 36. Page 40 is the petition, 36 is the type copy. What had happened, my lord?
This was the affidavit was signed by the CS order, but the petition is not accepted.
Huh?
Yeah, the page number
Is 43.
43. CS order has affidavit is signed by the CS.
It was sworn before the
Affidavit sworn before the CS order.
CS order, my.
Then what is wrong?
No, that
No,
is
no,
still wrong.
no,
Court
court has not received the petition, my.
Which court is this? Morigaon.
Morigaon, my.
Problem arises, I could have done many things, but that person, that application is pending now.
My lord.
When is the next date fixed there? When is the next date fixed?
That I'm protected.
I'm putting it on Friday. Just find out what's the next date. Taking up this thing and what this court intends is to do one thing. It don't get even enough. The three applications, the three interlocutory applications with ISC number 1022 of 2024, ISC 023 of 2024, and ISC 1021 of 2024 are applications 21 are applications filed for condonation of a delay of 82 days in preparing an application for setting aside the abatement, semicolon, for setting aside the abatement in so far as the petitioner number 1, as well as for substitution of the legal representatives of the petitioner number 1. This court has perused the grounds which have been mentioned in the application for condonation of delay, and in the opinion of this court, the same constitutes a sufficient cause within the meaning of Article Section 5 of the Limitation Act. Accordingly, the delay stands condoned. Taking into account the above, this court also takes note of that as few grounds have been mentioned for setting aside the abatement, which in the opinion of the court are reasonable. The abatement insofar as the response petitioner number 1 stands set aside. Further to that, this court taking note of that the right to sue continues in favor of the petitioner, in favor of the legal representative of the respondent number 1. of the petition number 1. Substitutes the applicant numbers 1 to 4. 1 to 4. 2. 1 to 4. As petitioner number 1.1, 1.2, 1.3, and 1.4 to the accompanying revision application, thereby substituting the original petitioner number 1. All the 3 applications accordingly stands allowed. The petitioner is directed to file a fresh memo of parties before the registry of this court by 6/35/2024. On the basis of the same memo of party, the petitioner, the registry shall make necessary changes in the course title as well as also update in the state TRS. Economic TRPIO 253. The instant application has been filed by the petitioner seeking a direction that the trial court should consider the application so filed on 5/6/2023. It has been alleged by the petitioner herein that the said application have not been taken into the file by the learned trial court, and as such, being aggrieved, the instant application has been filed under Article 227 of the Constitution. It is not known as to on what basis the said application, as to whether the allegations so made, it is not known as to whether the said allegations so made are correct. Under such circumstances, this court fixes the matter on 27th of May 2024. The trial court, that is the court of the, what is that court name?
Munsif number 1.
Where?
Moriga.
The learned trial court, that is the court of the Munsif number 1 at Moriga, is directed to submit a status report as regards a report as to whether the said application dated 5/6/2023 was filed by the petitioner before the trial court, and if so, why the said petition have not been taken up for consideration. This accordingly. The registry is directed to intimate the instant order to the trial court for furnishing a detail about the. Yes.
My lord, instead of Munsif number 1, it has been now, it is just during the time.
And the petition date would be 15/6. 15/6. Not 5/6, 15/6. The date of the petition date is 15/6/2023.
All right.
All right. Very pleased about this method regarding withdrawal of the plea and took a liberty to file the fresh suit. We are for the defendant, my lord, and the order dated 27/7/2023 is passed by the my lord learned Munsif number 2 Nagaon. The plaintiff filed one petition which is at page 49. At page 49, and it was my lord on that day it was fixed for my lord objection, but due to some difficulties, my lord, the advocate was suffering from some illness. He could not file the objection. The learned Munsif, my lord, without hearing, without giving any liberty to file objection, will allow the petition filed by the plaintiff.
Yes. What is this type of order being passed by the learned Munsif?
Lordship,
Orders you can't.
Lordship, yes. That is petition was filed on 5/11/2022. They got the opportunity up to 27/7/2023.
Whatever may be.
Lordship.
When they pass an order, they have to apply
Yes,
their
yes.
mind.
Lordship.
You see, what is the requirement? When
Lord.
can a leave be granted?
Lord.
The leave can be granted if you see an application for leave under the proviso to JR shall be accompanied by an affidavit of the next friend also, and if the this is not there, where the court is satisfied that the suit must fail by reason of some formal defect,
Lordship.
or there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter of the suit or the part of the claim. It may, on such terms as it may think fit, grant the plaintiff liberty to withdraw from the said suit or such part of the claim with liberty to institute a fresh suit in respect to the subject matter of the suit or such part of the claim. So,
Reasons to be shown. Reasons to be shown.
where is it? This is an application under Article 2 to 7 of the Constitution challenging. I feel sometimes like sitting out there, I'm just dictating. Every time. This is the second case.
Second case. I'm sitting here, Lordship. Lordship, that time on that case, what happened? There no opportunity was given on the same day. They were filing the application, petition was allowed. But so far, if this case is concerned, 7 months time was given to file the objection.
They give not 10 days time also or 5 days time also if it is done also or no. They have to record the reason.
Record the reasons.
This reason has to be there.
Yes.
It cannot be at the whims of the.
Lord,
That's when the suit is at the stage of plaintiff evidence.
Lord.
Suit of 2014 below.
This is an application under Article 2 to 7 of the Constitution challenging the order dated 27/7/2023, passed in title suit number 508/2021, whereby the learned trial court, that is the court of the Munsif number 2, Nagaon, have allowed the application seeking withdrawal of the suit with liberty.
Permission to file fresh suit.
With liberty to file a fresh suit. It appears from a perusal of Order 23, Rule 1(3) of the Code of Civil Procedure 1908 that an application for withdrawal of a suit with permission to institute a fresh suit can be done only when the court is satisfied that the suit must fail by reason of some formal defect, or that there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter of a suit or a part of the claim, and that too on such terms as it thinks fit. A perusal of the impugned order dated 27/7/2023 would show that the said permission was granted without the suit was withdrawn with the liberty to institute a fresh suit without recording any of the satisfaction which is mandatorily required in terms with Order 23, Rule 1(3) of the Code. The act on the part of the order which have been the impugned order clearly shows that the learned trial court did not apply its mind to the facts of the case as well as the provisions of law, and resultantly the said impugned order was passed. Consequently, the impugned order dated 27/7/2023 is set aside and quashed. This court directs the learned trial court to again de novo consider the application filed for withdrawal of the suit with liberty to file afresh. That is petition number 1375/2022 de novo. by giving due opportunity to the defendants to file an objection. Full stop. This court also takes note of that already the defendants have been given adequate time to file their objections. However, such objections have not been filed. However, in that view of the matter, this court, for the ends of justice, grants the defendant a period of grants the liberty to the respondent, to the petitioner herein, who is the defendant in the suit, to file the objections on the next date so fixed by this court. Taking into account that both the parties are duly represented, this court fixes the matter before the learned trial court on 27/5/2024, on which day the petitioners who are the defendants in the suit would be at liberty to file their objections. Failure to file the objection on the part of the defendants oblique the petitioners herein shall enable the learned trial court to pass appropriate orders by taking into account appropriate orders on the application seeking withdrawal of the suit with liberty to file afresh. By duly applying the yardsticks as stipulated in Order 23, Rule 1(3) of the court. Steps is not complete. Steps having not been completed, list the matter after completion of service upon the respondent. What is this IA for?
For condonation of delay.
How much?
For application, appeal. Condonation of delay.
How much?
600 something days. And there is no reason, and there is a mixed up. The whole petition is mixed up. It is like an appeal also, it is like a condonation petition also, without any reason. A mismatch. Grounds of appeal is also incorporated.
Anyway, none has appeared on behalf of the applicant on call. Mr. Your name?
SS Borwa.
SS Borwa appears on behalf of the respondent and who submitted that an objection has been filed to the application seeking condonation of delay. So, taking into account the applicant is not represented, this court for the ends of justice adjourns the matter to be listed again on 24th of May 2024. In the meantime, it is made clear that if on the next occasion the applicant is not represented, the instant application shall be dismissed for non-prosecution.
Yes. Filed an application under Order 1 for replacement of the legal heirs of respondent who died after disposal of the title appeal, but before filing the regular case.
Stating the address of the legal representatives of the respondent number 4.
Yes, we have filed an additional affidavit.
Yes, then you have filed it.
Yes.
Now who died?
Respondent number 4 died.
Within time. All resident of so and so. Now, what was this application I is for?
I was for, my lord, for implement of the legal representatives of respondent number 4.
Oh, this person died before that, something like that, no, if I remember correctly. Yes, you are appearing for?
1, 2, 3, and 5.
You have something to do with Order 1, Rule 10. Today, this is the second matter.
My lord.
Today, this is the second matter with order 1 rule 10.
Yes.
Yes. Yes, what to do? Dispose it, what to do? Tell me.
Including the legal heirs of respondent number 4. I guess respondent may not have any objection.
That's because I don't have any objection, but perhaps notices because I don't have instruction to appear on their behalf. I don't have instruction to appear on their behalf till now.
No, here is the case, order 1 rule 10(2) was filed. Why was it filed? Because they were already impleaded in the first appellate court.
Yes.
But they were not impleaded out here, you made it against the dead person. And now you want to bring in. What do you say about the limitation?
So far as limitation is concerned, had it been the petition for substitution,
There is no substitution.
for impeachment,
No, not for impeachment. It is a case where you have not filed an appeal against them. How do you take care of that?
inadvertent error.
Inadvertent error is you have done. There cannot be an inadvertent error. You have not filed an appeal against A, B, C, and D, who were duly the parties in the first appeal. Now, by way of an impleadment, you bring them and thereby regularize the appeal and make it without a limitation.
Order rule 10 to specify that the court has the power.
Court has the power, but the rights of them, wouldn't it be taken away? The rights of you not filing an appeal against them is not being taken away.
Because the suit was filed by them, the suit was defeated.
That is good.
And we filed an
You
appeal
filed an appeal, the appeal got dismissed.
along with the counterclaim.
Whatever may be, the appeal got dismissed.
Appeal was
So these people were very much there. So there is a decree in their favor. Now you have not filed an appeal against these ABCD.
the decree is only for right title and interest.
Whatever may be in favor of the plaintiffs.
Yes.
Now they were the plaintiffs. So these ABCD were not made a party in appeal. So you did not file an appeal against the proper person. And if you have not, can this court, exercising order 1 rule 10, do so, thereby nullifying the appeal which or the provision of filing an appeal against the correct parties?
So far as the appeal is concerned, if I may take a note to page 35, the legal heirs were not substituted because in the judgment apparently the name of Sanju Dev is appearing.
Then
I had
order 1 rule 10 will come in if during the pendency, post the decree and prior to the appeal, something like that. 146 and order 1 rule 10 comes there. How do you bring in order 1 rule 10 now?
we filed an appeal under the belief that since in the past appeal,
Who were to substitute? Who filed the appeal before the first appellate court?
we filed that.
Well, in fact, this proceeding should be at all closed. What do you say, Mr. Kunti?
My lord, that is correct, my lord.
I think this is a very pertinent question
My lord.
because they have not filed an appeal. So that appeal has attained finality
My lord.
unless you remove the limitation bar. You can't, by way of an order 1 rule 10, exercise your clever mind and thereby
Now, my lord, including
thereby
that.
this court should pass an order.
But the access to the power to be, my lord, from the date of knowledge. But we came to know about this death of respondent number 4 during pendency of the regular second appeal. And so far as the past appeal is concerned, we're not here.
Understood. Then also you are to ask for substitution. If you ask for substitution, this court then has to remand it back to the trial court, the first appellate court, where at that stage he has died. Mr. Deka, remember the judgments, I think many judgments are there on that aspect. Where the death has occurred, you are to file your substitution. The substitution application is to be considered by that court, not this court. This court will have to remand it.
I'll have to,
Huh?
I'll have to see sometime maybe.
Please. So you were asking for disposal. This is not possible. You see, after vacation, have a wonderful monsoons out here. See the bright and greens weather, and then apply your mind. But
After a week,
no, this matter has come twice.
the last time due to vagueness in the address, your
Huh?
lordship, due to vagueness in the address, your
Vagueness
lordship
of
would not-
address, whatever may be. But as of now, this has happened. This is a very serious thing which you have done. How do you do it? How do you tackle that? Because there is a decree against that. Otherwise, you will be many. You may very well do many things because it has to be a fresh appeal. You have to file a condonation because otherwise, the decree there is already a decree against that person. Think about it. How much time? 1 week is too late. You do one thing. You'll get an order. I may not be there from the 1st and 2nd week of June.
Then, my lord,
Let the matter be on 3rd of June.
So lordship takes up the matter.
No. Let it be on 3rd week of 3rd of specific. Get that. Yes, Mr. Sen.
Hello, the office note dated 7th.
Service not complete leaves the matter after completion of service. No, I can't because service is not in my hands or in the hands of the registry. The service is squarely in the hands of the registered post people or the processor, which I don't have a control.
Please, lordship. Also, in this case, we were supposed to file affidavit, lordship.
For what?
Lordship, he has filed an IA for seeking permission to renovate the lordship shop house.
You want time?
Yes, lordship.
Ms. Coenco, appearing on behalf of the respondent, submits that 2 weeks' time may be granted to file the affidavit to the application. It is seen that on the earlier occasion also time was sought for. However, no affidavit has been filed. Accordingly, this court fixes the matter on 31st of May 2024. It is made clear if the affidavit is not filed on or before 29th of May, the instant application shall be taken on the basis of the present.
Okay.
Notice may go.
What notice?
Delay condonation petition.
What is this arbitration appeal?
Lordship.
Under 37. 37, 34 will apply or not? What has happened? That matter was here, the Supreme Court says, and thereupon the matter, I think, was reviewed. Hello? 278 days.
278.
You filed an application for what? Setting aside.
No, I filed an application for section 9, your lordship.
Then?
That was dismissed.
Issue notice. Turnable. Steps by registered as valid.
Oblige you. Notice was issued, my lord.
Service complete.
That is complete as per office note dated 25/4, my lord. Except, my lord, respondent number 1, Roman 4, not, my lord.
Which is 4?
4, my lord. 1. Onu Palata. Onu Palata. But his signature in the Okalatama is there, my lord, or no profada?
Who is this? Service not of complete upon Roman 4. Well, reach the matter again after 2 weeks. So the registry shall ascertain as to whether the service upon the response number 4, 1 point Roman 4 is complete. And yeah, to list the matter again on 29th of May.
This matter, my lord, I have just been informed.
They've already taken your.
They-
They've already testified.
Please just inform me about this matter. I have not received the petition.
You have not given?
Already I have served notice only. As doctor.
I am not as
We'll have it on Samadhi. Earlier, Mr. A. Ganguly was appearing.
It is not in this case, your Honor.
Another matter, na?
Yes, your
So that day I got hold of him and asked him. He said, okay. You appeared.
this matter.
In my time.
Tribally, my lord, I appeared, man.
Huh?
Last occasion I appeared.
Before me?
Yes, I remember this matter.
It's 10 days.
10 days.
Yes,
10 days.
yes. If your lordship will have the record, my lord, I have filed the affidavit, man. Here, my lord, I have mentioned the calculation, man.
I have given academic in my review page also.
Miss Toenso, the Miss M. Oza,
MAU.
the copy upon
Yes,
Mr.
sir.
Toenso by during the course of the day. List the matter again on
Tomorrow, man.
10th of May. 10th of May.
In the other item, my lord, item number 26, my lord. 26.
Oh, you got the date?
Yes, yes, my lord. My lord, the e-code, I have checked the e-code, my lord. It is showing as disposed of, man. In the e-code, my lord, it is showing as disposed of. I just got a printout.
No, there must be some say. What is this disposed of?
E-code website, man.
It was a matter pertaining to what? Which one?
Withdrawal with liberty. That matter.
So that was allowed.
Yes.
That is why.
Yes, yes, that was allowed.
That
but
is why it could not have proceeded.
Yes, that was allowed. But in the main suit, the learned court below was giving on dates after date. That was the issue. I verified in the e-court website, my lord. Now it has been showing as a disposed of. So your lordship can fix a date for our appearance.
Okay. Inform the other side.
Yes.
We'll have it on 3rd of June. 3rd of June before the
Yes,
trial. Hey, 26 to June. Yes, Mr. Tomo.
My lord, there's a IA for condemnation of delay of 2 days, my lord, in preparing the testamentary appeal.
You lost out on 2 days.
Pardon?
You lost out on 2 days. You have to exercise. You have to take a painful exercise by issuing notice.
My lord, for 2 days, the lordship will be kind.
2 days, this can only, huh? You have to issue notice to them, na?
My lord, to issue notice.
The big lot. Big problem. Only 2 days. Anyway, where are they? They are in all these things. Okay, issue notice making it returnable by 4 weeks. Steps be taken by way of registered as well as you.
I'm okay.
Yes, what is this? Why LCR is required?
Yeah, doctor.
Or records not come?
Yes.
Oh, this is land grabbing, na?
Yes, ma'am. Sir, I have filed wakalatnama on behalf of all the
call from the not yet received. From a perusal of the office note dated 29/4/2024, it revealed that the LCR call from the additional session judge number 2, Nagaon, Assam, have not yet been received. The registry shall take effective steps in the matter and forthwith requisition the records of special land grabbing case number 9/2018 from the Court of the Additional Session Judge number 2 of Nagaon, Assam on the next day, on or before the next day. So this court fixes the matter again on 10th of June 2024.
Well, I do bless.
What is this?
Hello, we filed a petition for the action of the interim order.
Interim order?
Hello, here, Prophet has been granted, my lord. Prophet was issued also, my lord. But they have-
Interim order, what is there to take it?
My lord, they, on the plea, my lord, that there is no signature of the, my lord, on the first page, which is not correct. My lord,
Is an ex parte judgment?
not my lord, others, all others, my lord, they filed joint written statement. Thereafter, they say, no, this is correct, that will be, Prophet can be granted. Others file no NOC and orders are.
He did not.
He did not participate in ex parte. Yes.
He filed a written statement.
Yes.
Along with them, my lord. Along with them. Thereafter, he did not appear. My lord. He did not appear.
Now he's challenging.
Now, my lord, challenging, but partially saying that the signature of the testator is not there in the first page. That is not correct, my lord. He has taken a copy. I
Hello.
don't know where
We'll
from.
do one thing.
He has taken a copy. I
Is
don't
the
know.
matter on May 2024?
Appeal can be disposed of, my lord. Because this is the only point.
That is the question. 23rd of May 2024. On that day, if it is not possible to dispose of, if this court, on that day, an attempt shall be made to dispose of the instant application, the appeal. So, in the circumstance the appeal cannot be disposed of, this court shall take up the application for vacation or modification of the interim order.
Much obliged.
Reconvert. Yes, what is this? Within time?
Substitution of legal representative, my lord.
Within time?
Appellant right, my lord.
Within time?
Within time, my lord.
Is an application on whom died?
My lord, the appellant.
Appellant.
Sole appellant Abdul Majid died, my lord. In para 3, my lord, the legal representative.
This is an application filed under Order 22/3 of the Code of Civil Procedure 1908 for substitution of the legal representative of the appellant, appellant Abdul Majid, who expired on 9/11/2023. So it appears from the state application that the sole appellant is survived by his legal heir, whose names have been duly mentioned in paragraph number 3 of the application. Taking into account that the right to sue survives upon the legal representative of the appellant, of the original appellant, the instant application stands allowed. The petition and the applicant, the counsel for the applicant is directed to file a fresh memo of parties before the before the registry by 6/5/2024, and on the basis thereof, necessary corrections shall be made to the cause title of the accompanying regular second appeal, and also update the same in the CIS. I sense this.
I for correction.
Huh?
I for correction.
I for
Correct.
what correction? What have I done?
No, this order was passed by came to the board.
Oh, what has happened?
Lordship MS number 02/2023. This should be 02/2020.
Where?
Paragraph 5, page 7.
Honorable State.
23. It should be 20.
Should be. Where's the other side? It was
To
past
other
ex
side-
parte.
Yes, we have no. State Bank of India was the party.
Okay.
We have already taken steps. Lordship, they have not implemented.
02. Where will I get it? 02. And the problem arises now, the order is not clear.
In fact, that is the problem. Lordship. The
Huh?
order is not clear. It's written as MS, whether it is 01 or 02. It's not clear.
02 oblique. And down below you have to mention as 01. Then you see, you don't know which case you have filed. You have to be more careful. 02. Order was passed as 02.
Lordship.
Then what is wrong? 2022 or 23?
It should be 22. In fact, in the order which is under challenge,
22.
23. It is written as 23,
stop.
but it should be
Yeah,
22.
this is an application filed for correction of the order dated 6/11/2023, wherein this court had issued notice and had also stayed the further proceedings of money suit number 02/2023 pending before the Court of the Civil Judge Senior Division West Karbi Anglong Hamren till the next returnable date. The learned counsel appearing on behalf of the applicant submits that there has been an inadvertent error in as much as the proceedings in question is money suit number 02/2022 and not money suit number 02/2023. He therefore submits that the instant application has been filed for the correction of the said aspect of the matter. The court have also perused the accompanying application filed under Article 227 of the Constitution, and from a perusal of the materials, it reveals that the suit in question is money suit number 02/2022 and not money suit number 02/2023. Accordingly, this court makes correction to that typographical error which had occurred in the order dated 6/11/2023. Thereby, the money suit number 02/2023 as appearing in paragraph number 5 shall be read as money suit number 0/2022. The instant order shall be a part of the order dated 6/11/2023. I sense. Yes, what is this? Review for what?
Review for order dated, my lord. 1/12/2022. That order was passed, my lord. There is a civil division. I'll give the background of the case. There is a civil division. I am the decree holder, my lord. And I institute the execution case, my lord. In execution case, my lord, there is a attachment order was against that attachment order, my lord, they came before the Senate. And in fact, my lord,
Isn't that the confusing matter?
Yes. No, I have my
Where
learned friend has
you
found out.
feel like you are still in the cloud.
Yes. Now I can clear the cloud. If my learned friend, what has happened, my lord,
Anyways, we'll do one thing.
Fine.
Let's take it up on Thursday.
my lord,
Finish it up.
possibly, my lord, my learned friend is appealing for the railway. Since they have withdrawn their appeal against the enhanced award passed by the reference court, he is trying to find out whether the entire amount has been paid or not. If it is not paid, they will have to pay because they have withdrawn the appeal. So
I think she, no,
Appeal filed where?
before this one report.
So what is the problem? What is the number of the
No,
appeal?
they have withdrawn the appeal.
Then
Well,
what do you mean?
That's what I am saying, madam. They
We
have
list the matter with the date appeal.
no, what she is
So,
trying.
my lord, why
Madam,
I'm
she is
asking in the by the
no, madam, she is trying
this
to.
order, my execution proceeding means my lord finished. They have to close the execution proceeding.
Understood.
My lord, whatever amount.
Let us finally do the matter
Yes.
on some other date.
Yes.
Already
My lord,
4:30.
My lord, yes.
tomorrow.
Huh?
Let it
Tomorrow,
go.
tomorrow, Thursday also not possible. I have got a long list on Thursday.
Let it be a Tuesday, Wednesday, Tuesday, madam.
Because this matter,
Tuesday is a holiday.
huh?
7.
7 is closed. 9.
9, my lord, not 9, my lord. Second matter. Not 9.
Let it be on a hearing day. Take 10 minutes.
No, it won't take hearing. The matter is not fit for hearing. We'll do it. We'll have it on Friday, Monday on 6. On 6, we'll have it with liberty to mention for upgrading.
Yes. Yeah.
This is the matter on 6/5/2024. Oh, sir. Liberty, however, liberty is given to the parties to mention the matter for upgrade. When did he die?
15 January 2024.
How many applications you have filed?
2.
You have died only recently.
Yes.
এখন দুইখনৰ বেলেগ বেলেগ না এখন নম্বৰটো কিয় এনেকুৱা কি ফাইল কৰিছে এইটো 132 order to 132 একেই হ'ব না both are same appellant na
Yes.
This is an application filed by the applicant who are the legal representatives of the original appellant who expired on 15/1/2024, leaving behind the applicants whose name appears at paragraph number 2 of the application. So, taking into account that the the right to sue survives upon the appellant, upon the applicants, upon the death of the deceased appellant, the applicants herein whose name appear at paragraph number 2 of the application are substituted as appellant number 1A and 1B to the accompanying application, to the accompanying appeal. The counsel appearing on behalf of the applicants are directed to file an memo of parties before the learned trial, before the registry of this court by 6/5/2024, and thereupon the registry shall make necessary correction in the records in the cause title of the accompanying appeal and also update the same in the CIS, taking into account that the RSA is of the year 2004. The same be listed for hearing on 21st of May 2024. Ikon dile ikono to eke hob, ha? Both.
Okay.
Yes, Mr. Bhatti. What is that matter?
I thought Bhatt but
Records have come. No, not records are not necessary.
He was the defendant. I filed the suit for injection of the defendant because it was my training. And the suit was decreed expired. After expired, they put
It was decreed ex parte. How?
in my view because it did not appear. in spite of the
Service of summons, he did not
Summons-
appear.
summons, it was hanged.
Okay.
So that, and it did not appear according to expert was asked. When I started the exhibition, he filed an application or nine, but was set me as a and was a teacher for 300. 345 days delay. And delay was not properly explained. And according to the report, dismissed that coronation petition subsequently.
Allowed the condonation or dismissed?
No, dismissed.
Okay.
And according to the petition the side of the organized against that one,
They filed an appeal.
in appeal, my lord, the matter was that it is very cryptic without considering whether they were sufficient explained or not. And that you also will find at page 60. The reasoning given is at page 21.
Where is that order of the appellate court?
16, page 16, 1 6.
1 6.
1. And the reasoning which has been given at page 25. Even though, my lord, the appeal was partly disposed, so far the application under order 913 is concerned. The learned trial court has been directed.
What is the ground saying where perusal of a petition in so and so that the appellant has been sustained showing that the summons was not served upon her in the process. So in pursuant to its that has not adopted a fair approach in with respect of service of summons on a man and individual.
He just an discussion it has
So there is no medical document, nothing.
Nothing.
And he was not for 345 days. But was it the case of the plaintiff at any stage that she knew about the summons?
Yes, he knew because otherwise he knew about because near to her, by one of the places.
No, understood. But how does the delay of 345 days come?
Because he did not achieve that goal in spite of the 30. And his son was but at the time of making the 30, his son was but in 34. So Lord will see the report at page 30.
No, one thing I don't understand the delay. Now, whether she accepted that the summons was served and she could not participate because the trial first appellate court judgment seems like that.
At the time of service of the summons, he was not present. And his son was present, her son was present. My Lord, your Lordship will come to page 32.
Yes, kindly see, Mr. Bhatti, one thing why I am saying so, there is a reason why. This appeal dismissed on contest. What is this SAO and what?
32, your Lordship may look at page 30.
Where is the order? The impugn order, where is it?
Impugned order, your lordship will find at page 16, 16.
16. Yes, yes. Kindly come here. I'm not able to understand this as per page 21.
Page 21. Yes.
In any case, the 7 lines or 8 lines from the top.
Yes, in any case,
In any case, when a process server endorsed the service of summons through verification, the process server ought to have been examined on oath, and thereafter any decisive order needs to be made. Now, whether the process server at that point of time had given an affidavit,
yes,
that is what is required.
yes, that is.
If they want to cross-examine, it's a different thing. In that perspective, the summons upon the air was not properly appreciated. Regarding condonation of delay of pre-sale, which is a matter of present appeal, it is pertinent to mention that the appellant was engaged in the treatment of her son who met with an accident, and this might have been one of the probable grounds for which the appellant was not in a position to contest. I don't understand how to bring this aspect. Both cannot go together. Anyway, so we will fix it, taking into account this court prima facie has found that the petitioner has a. So we will fix when. It's the matter on 5th. 5, 6, 9, 9th of May 2024 at the top of the list, and show it as part heard, taking into account that the counsel appearing on behalf of the petitioner have been duly heard.